Fair play, Lord.
One.
Fair.
Yes.
My lord, I am having item number 67 of supplemented. It is a demolition matter, Lord. Demolition is fixed tomorrow by the DM.
Item
My
number?
lord, may be upgraded and taken it to
Item number?
Lord.
67.
Sanjay Mathur.
Sanjay Madani.
Demolition is fixed tomorrow.
We'll take it up. Before what?
Maybe.
Yes.
My lord, item 61.
I'll take it up, Mr. Roy. I'll take it up after motion.
Okay.
After the motion items, I'll take it up.
My lord, I beg to mention item 61. This should, my lord, this may be taken up as an admission matter. So, Lordship, it has been wrongly listed for orders. Lordship will take up after the last admission item as a last.
That is the Lord. Because I think it's an item number 16 of today's date. Can be vendor. Item number 1.
Item number 16. At the request of the learned counsel for the petitioner, matters petition be listed after 6 weeks. Yes.
Please, the Lordship. Lordship, I beg to mention one IA for listing tomorrow, Lordship. In this case, what happened? It's a CRPIO, in fact, but Lordship, being the parties are advocates of this court, Lordship, matter was taken up in camera proceeding for settlement. Thereafter, Lordship, it was sent to mediation. A mediation report already sent, Lordship, that mediation cannot be settled. So I have
Why
filed-
tomorrow?
Lordship, I have filed this IA praying for maintenance amount, Lordship. That was
So what is the urgency?
from
You
12.
can't wait till Monday.
Lordship, from 12, my daughter's exam is there, Lordship. Before that, I have to pay some amount. So on 11th also, if your Lordship, tomorrow if possible, then on 11th, Lordship. If tomorrow possible, Lordship,
Not tomorrow. Leave it on 13.
30th, Lordship. Can it be on 11th, Lordship?
11. Okay.
Obliged, Lordship.
Your Lordship, may please your Lordship. I'll add item number 8, your Lordship, on petition on behalf of my senior, Dashboard PR for the respondent. I've taken the consent. Can we please matter be adjourned for a week, Lordship?
No week business. List the matter at the request of the learned counsel for the petition respondent, and with the due consent of the other side, matters can be adjourned to be listed after 6 weeks.
Item number 27.
Hmm.
The Angus has expired. I inform the party.
You want an adjournment?
Yes, my lord.
Adjournment.
Maybe adjourned, my lord.
You are for the
Expired. Angus Council is the 8th. Expired.
who expired?
8th. 8th Angus Council.
8 day expired.
Expired.
So
I inform the party that they are going to get some other set of property. Something like that.
okay. 27. The request of the learned counsel for the appellant, matters can be adjourned to be listed after 6 weeks.
Please, the Lordship, I beg to mention item number 19, Lordship.
Hmm.
And as per instruction of my senior, I want to proceed.
19. Your name?
Here, thus, on behalf of Archie Potter.
No. Ask these people to come. Ask the lawyer to come. No. This cannot happen like this. Because I will withdraw it, and then tomorrow these are appeal matters. Normally, withdrawal of appeal has to be done in terms with order 23. But this is to be done in the, if you want, ask the person to be present.
Item number 55, can it be after 1?
55.
I took the consent on the time. for the-
Why? 1 week?
Lordship, actually, 5 days.
Okay. Take more time. I'll give you 6 months. At the request of the learned counsel for the respondent, matters can be turned to be listed after the publications. Yes.
Lordship, I beg to mention item number 13, Lordship. Lordship may not like take up this matter, Lordship. I'm for the petition.
Why?
Lordship, as a counsel, of the respondent number 1, 2, and 3.
In this matter?
Yes, Lord.
Okay. We will listen before any other bench.
13, 1, 3.
Next,
Obliged.
Item number 36. We have taken.
33. Yes.
This substitute arbitration.
Item number
36.
36. Yes. Who is out of station?
AM Borbu.
There is a stay. Then we'll make the stay absolute. If you are not willing to do the matter, these CRP IO matters cannot stand. I think the first day it has to be notice issued, and the second day either dismissed or allowed. Nothing more than that. We'll see when the matter reaches. Next,
That issue, Lordship, I beg to mention item number 12. May your Lordship adjourn the matter for decision.
yes, what is it? What do you want?
Adjournment.
Why?
Lordship, it's a family dispute matter. Parties, I have been informed, parties want to settle. So Lordship, we need some time.
It's a CRP IO. We vacate the stay. Okay. Don't mention all these CRP IO matters. Next, anybody else?
My lordship, I beg to mention for item number 4. My lordship, the senior legal counsel is dragging a traffic jam. For time being, can the matter be taken a second? My lordship.
Traffic jam. Okay, you do it when the matter reaches. Next,
I am praying for listening this IL. IL is for correction in the water path.
by me?
Tomorrow.
By me? Today?
Tomorrow.
Not tomorrow, today.
May you please the Lordship, I beg to mention an FAO for withdrawal.
Very well. When do you want it?
It is tomorrow,
Not tomorrow.
or on Monday.
Monday. Yes.
Order.
Why?
Take the order. Not a visit. Order better.
Orders?
Yes,
Okay. Wednesday.
It's important to the other section. I beg to mention item number 7.
Yes.
Maybe adjourn for the day.
Why?
I need to prepare the matter.
You can't prepare the matter of 2022. How long does it take? 2 years have passed by. Matter pertains to what? Landlord tenant.
No, it that's.
Huh?
Injunction. Not granting of injunction.
Non-granting of injunction is a CRP.
Step.
Don't mention all these type of matters. Next. What? You want to withdraw? When? Next week? Okay, next week.
What's on item number 1?
We candidate matter, I am also a bit confused in this case, but because during the pendency of the appeal filed by us, the other side told respondent and plaintiff died, but no information was given to us, nothing was put to us. And after the judgment passed, it is a second appeal. Then only the heirs in the execution proceeding point.
You are challenging what order?
While the order imperial order is 19/1/2024 in a 30 page 46.
This is a proceedings under section 47.
Yes.
Then
Follow?
you filed a proceedings under 47.
Yes, that was it.
That was dismissed. Then why? Without cause. Oh. Dismissed without cause. Yes, what is your point?
Point is, my lord, the person died. That is where I am confused. The person died, the sole respondent died. He was a plaintiff also. While pendency of the during the pendency of the second appeal, and they didn't put any notice or intimation that he died. So we could not substitute them. And even the lawyer for the sole respondent, he also didn't file application, any application under 22 Rule 10A
Who was the appellant in the second appeal?
We are the appellant.
Then the second appeal abated.
But my point is, Manor, it does abate authorized.
Second appeal had abated.
Yes.
Then why is section 47 filed?
Manor, after the judgment of this court, the man died before the judgment in second appeal. No intimation given, we could have substituted. It is not our fault. They should have intimated, the heirs should have intimated us that we are the heir, and this is the debtor. After that was done, then in the execution proceeding, they come and file. They file the exempt case and also for substitution. But in the substitution application, they do not disclose the date of grade. And we are not taking. Then we objected to it. Court did not accept it. The section 47, whatever is pending, execution court did not accept it.
Let us see what is your ground of section under section 47.
My application is Manor, NXLP page 24.
Page?
24. And that was the substitution also time bar under Article 120 of the Demolition Act, by about 4 years.
So what is wrong? The plaintiff filed the suit.
Yes.
The suit was decreed.
Yes.
You filed an appeal.
Yes.
That appeal was dismissed.
Yes.
Then you filed a second appeal.
Then
The second appeal was dismissed.
Yes.
But during the pendency of the second appeal, the plaintiff had died.
Died.
So under such circumstances, what is the problem in executing the decree? Your appeal abates.
Manor,
You don't have a case.
yes, but Manor, because I'm also under that, I've submitted, Manor, I'm also confused on this point, because it was not our fault that we failed to substitute.
Not necessary, but your second appeal was dismissed.
This was, of course,
So under such circumstances, if the second appeal has been dismissed, the appeal which was being, the suit which was decreed, the decree stands. Rightly or wrongly, the decree has attained finality.
Yes.
So under such, what is wrong with the execution?
execution is not, and the substitution application was time barred.
Which application? Before the,
Before the executing court,
before the
before the executing court, they filed substitution,
substitution application was time barred.
time barred.
How do you say so?
Yes, because the appeal was, second appeal was dismissed, decided on in 2015.
Ah.
The person died in, before that. And the substitution application filed in 2018.
Hmm.
It was time barred by 4 years.
So what?
Well, that could then be entertained by the trial court.
How do you bring in order 22 into a proceedings of execution? How do you bring in? You can't bring that. Taking into account, have a look at
No.
141.
I didn't bring that. It was the
Mr. Sharma,
respondents, yes, who brought the
Mr. Sharma, kindly see 141 of the code, section 141 of the
Yeah.
code. It categorically says that the procedures which have been mentioned out there shall not apply in respect to the execution application. So under such circumstances, the execution proceedings is a separate proceeding.
Separate proceeding.
Then why not just for example, a person have died.
Yeah.
Are you saying the limitation for seeking an execution is 12 years?
12 years.
So in the meantime, if somebody has died, the plaintiff had died who have got a decree, he can't execute. He after 10 years, 7 years or 8 years, he cannot file an execution application.
Before 12 years, Manor.
Then what is wrong? No case. We dismiss it right away. This is an application file. Heard Mr. R.P. Sharma, the learned counsel, senior counsel, appearing on behalf of the petitioner. This is an application under section 115. Is it 115?
No, no, 227.
How can you do a 227? Anyway,
Because
under Article 227 of the Constitution, for quashing of the order dated 19/1/2024 passed in Miss J case number 35/2019 in title execution case number 7/2018 by the Court of the Civil Judge, Junior Division number 1, Dorong at Mongoldoi. A perusal of the impugned order reveals that the said order has been passed in a proceedings under section 47, read with section 151 of the Code of Civil Procedure 1908. For short, the code. The basic ground on which the application under section 47 was filed, challenging the executability of the decree, is that the plaintiff, who was the respondent in the second appeal, being RSA number 30/2005, had died during the pendency of the said appeal, and under such circumstances, the decree, and under such circumstances, as the plaintiff was not substituted during the second appeal proceedings, the decree is inexecutable. This court have duly taken note of that the decree in title suit number 16/2017 dated 30/6/2006 was passed in favor of the plaintiff. Thereupon, the said appeal preferred by the petitioners herein, who were the appellants, was dismissed by the judgment and decree dated 22/9/2004. Subsequent thereto, the second appeal was filed, being RSA number 30/2005, which was, however, dismissed by this court on 17/7/2015. Even taking into account that the decree holder had expired during the pendency of the said second appeal proceedings, then also the second appeal, then also the non-substitution of the legal representatives of the decree holder would have abated the appeal. The same would not, however, affect the judgment and decree which was passed on 30/6/2006 in title suit number 16/1977. So consequently, this court have also perused the order dated 19/1/2024, which have been passed by the learned trial court, by the learned executing court, and is of the opinion that the same that there are no error of law as well as error in exercise of the jurisdiction. Consequently, this court finds no merit in the instant proceeding, for which the same stands dismissed with cost quantified at rupees 10,000.
Four petitioner, four capital and.
No.
Without.
However, in the peculiar fact of the case, no.
Alright.
Yes, what is this?
Lordship, CRPIO lordship injunction paid by the petitioner not to disconnect the electricity connection. But lordship, trial court granted injunction saying that the electricity will not be disconnected, but in the meantime, I have to pay the 50% of the bill amount. Challenging that order, lordship, they have also filed PCP and the petition also filed the application. The first appellate court says lordship, amount which was earlier that I have to pay in installment 15,000 along with the regular bail amount, and if it is not paid within 15 days, then they are at liberty to connect the electricity. Challenging that, I have the lordship. In my plain lordship, I have challenged the preparation of the electricity bill. There are numerous illegalities. since 2010, 2013, I have paid the bills, Lordship, but they have included the entire period from 2010 to 2021 and prepared a bill of rupees 94,000. Challenging the-
Madam, kindly see the order of, you are impugning the order dated 23/2/2024.
Yes, Lordship.
The last paragraph of that page, at page
The
57.
appellate side.
Since the appellant, you are the appellant,
Yes, Lordship.
has no dispute about the against the bills from June 2018, which is amounting to 1,44,520. As such, the appellant side is directed to pay the said amount in installment per month at a rate of 15,000 per month, along with the current demand of the bills issued against his consumer number and ID of more than 15 days, the respondent shall be allowed to do. So what is wrong with that order?
Lordship, I am not, Lordship, I am disputing this amount.
It
The area
is
amount
said
and-
that it is not disputed.
No, Lordship, it was from where it is written, I have no idea, Lordship.
Let us see where is your appeal memo.
I have not connected. Lordship.
Then you should dismiss it on that ground itself.
Plain, from plain, your Lordship will find.
Why did you file the appeal?
Plain and injunction there, your Lordship will see that the main suit is regarding preparation of the illegal bills, Lordship. I have.
Madam, you pay that amount. You pay that amount of 1,44,520 in this installment basis,
Lordship,
that amount per month in installment basis,
that
and that will be subject to the outcome of the suit. That's all.
Lordship, my suit will become infructuous.
Huh?
I have filed the suit challenging the preparation of these, Lordship.
Understood?
Since 2010, Lordship, I am objecting
Yes.
that they are preparing the bill, Lordship, on estimated amount. They have replaced the meter, Lordship, in the year 2010.
Mm.
Everything I have.
Then you, I
my
think
name.
you are a tenant.
No, Lordship, I'm the owner of the house. It's my residential house. Lordship.
Then who is against this? This is against whom? APDCL.
Against APDCL, Lordship. Your Lordship, kindly go through the bills which I have annexed. Lordship.
First of all, where is the question of granting an injunction against this, a bill? You go and file an appeal. 127,
Lordship, I have.
isn't it? Alternative remedy is there. So we dismiss the entire proceeding.
Lordship, there are disputed questions of.
There's no
facts which they
disputed,
have-
that disputed questions of facts can be very well decided under 127.
But Lordship, suit
then
was
you-
filed,
when,
they are
uh,
contesting,
oh,
Lordship.
Within the provisions of 41 I, J, what is that?
Lordship, the exit,
Of the
of the
specific relief act?
that,
Have you ever seen the act?
no, that's not.
No. Yes, madam, take it out. Specific relief act,
But regarding the dispute of.
wherein it says that that amount, if there is an alternative efficacious remedy, then no injunction should be granted.
Section 34.
So the entire injunction granted of giving you 15 days time is also wrong.
Lordship, suit is pending. My question is.
So
is
what,
the entire-
first of all, the question of granting an injunction does not arise. Whatever you have been given out here, I think that should be the best part. You should be happy with it.
Lordship,
You are given now
I am
to pay
disputing
at
that amount.
15%. The entire thing has been made to be paid. 1,44,520 has been said to be paid in installments. You should be happy with it, and that will be subject to the outcome of the suit.
My bill amount earlier was 94,000. Now they have, during pendency of the induction, they have said that it is 1,42,000, 1,34,000. How they calculated the entire bill amount. I have annexed some bills here, Lordship will find. For the same period, Lordship, 3 bills were prepared.
Why should this? Oh, you should have filed the suit.
Lordship, that is why the suit is pending and the entire relief in the suit which I sought for.
This
Lordship, that
injunction,
was
granting
granted.
of this injunction, I think we can do one thing. We can set aside this injunction. You go ahead with disconnection. It's not done. How can you? There's an alternative remedy out there. Absolute alternative remedy. How can you grant an injunction? You should have that. If you are agree with any assessment being made, this is an assessment made.
Yes,
Yes,
Lordship.
Lordship.
Assessment on the basis of an assessment being made, the bill has been given to you. You have any problem? There is a particular, what you call, You have a forum,
In
no?
fact, yes, we have already forum also.
There's a forum out there.
Yes,
You go
consumer
there.
grievance.
You should have
Lordship,
gone there instead of filing a suit.
RTI, Lordship.
It
I
is
have
very
done
good
my
to file
RTI.
a suit, get it stayed, and then the APDCL would not be paying. Everybody will
Lordship,
do
I'm
that.
ready to pay after the suit. I'm ready to pay, Lordship, the entire amount if they calculate it, Lordship, properly.
This is not, madam, this is not a case for filing a suit. You have unnecessarily prolonged, unnecessary, it's an unnecessary litigation.
No, Lordship.
You
since
have any problem out there?
2010
There is a forum, madam. There's a proper forum.
I
You should have
agree.
gone there.
That I agree,
Then-
Lordship, but Lordship, I have till 2010, I am pursuing this matter. I have filed
If
different.
you have any wrong, it is for the appellate forum to decide. There is an appellate forum out there.
Yes.
Lordship, kindly see my representation, annexure 1 series, Lordship. That is annexure 2 SDO STP, Lordship. I have filed my objection before them in the year 2015. Please verify the meter and then calculate the bill properly, Lordship, without going for it estimated bill, Lordship. As already I have paid the meter rent and meter was installed. 2015, 17, 18, 20, 2021, I have regularly filing my objections before the SP. They are not taking up the matter and then finding no other Lordship alternative. I find the suit.
Why did you file a suit?
Suit, Lordship, the bill amount which was given issued, Lordship, in the year 2021. That is excessive, Lordship, and the amount which I had already paid in 2013, that was also included in the bill, Lordship.
Lordship, since 2013, no bill was paid and the petitioner is enjoying it.
No, Lordship. They
And it
have
is the
not
admitted case of
initiated any
the
proceeding,
petitioner.
Lordship. They have not installed the Lordship meter. I have paid the meter rent also, Lordship. That was also closed there. So, Lordship, kindly see my.
No, now only one thing, Mr. Counsel.
Lordship,
How does the amount come to 1,44,000?
that also, Lordship, I have to also verify.
We do one thing.
Lordship,
We modify, we dispose of the matter, modifying it because the dispute before the
94,000.
court
yes.
was only 94,000.
Yes.
So they will pay in
Lordship.
now less than that.
Lordship, 94,000, Lordship, included the amount paid here also. 2013, I have Lordship paid, that is admitted facts. They also admitted that since up to 2013, I paid, Lord. It is reflected in my plaint also, Lord.
Lordship may dispose it of with a direction to pay
And in
94,000
the
amount.
orders also, it is reflected that Lordship, since 2010 to 2013, the plaintiff paid the bills regularly, Lordship. That is to the estimated bills, Lordship. Page 25, your Lordship, kindly see in para 7.
Madam, two options. This court is going to dismiss. You want to pay that 94,000 in this, that can be done because the subject matter was involved before the trial court was there.
94.
Any other area bill, it is to be paid because the learned appellate court had taken into consideration the future bills.
Yes.
Whereas the subject matter was as regards the 94,000. 94,000 you pay, that will be subject to the outcome of the suit.
Lordship.
Lordship, 95,000 also included the bill amount
Okay.
which I have paid.
Okay, then I'll dismiss the entire thing and
Kindly,
write.
Lordship, kindly consider my case,
The
your Lordship.
instant
I am
petition,
before the learned
no,
appeal.
madam, sorry. The instant petition under
Then your
Article
Lordship
2
may
say,
give some time, Lordship, I will take instruction from pen whether he is ready to pay the 92,000.
whether he's ready or not, you disconnect then.
Lordship.
This is as if you are being asking, you disconnect the electricity immediately
Lordship.
and then let them take the connection.
Yes, Lordship.
We will consider after you. You
Lordship,
disconnect it
Lordship,
immediately.
kindly consider there are.
No, not
Some idea-
necessary. Madam, the question of, this is a question of payment of electricity bills.
Lordship, I am ready
First
to
and
pay.
foremost, there is a forum, not only under 127, you have a forum.
Yes.
If there is an electricity dispute out there, you can very well raise the dispute
Yes,
before that
consumer-
forum.
That-
You have not done. Madam, I also know why you have filed the suit. The filing of the suit will only prolong the non-payment and get an injunction of the entire amount.
No, Lordship, the endeavor of the plaintiff kindly consider their file representations, Lordship, year after year.
Hey,
Lordship.
specifically, you respond.
Lordship, the representation, your lordship kindly see that.
I am not going to look into all this representation business. There is a forum. You should have approached that forum, which you have not.
Consider the plaintiff will approach the forum, lordship.
We withdraw your suit and approach the forum
That may kindly be,
within 15 days.
that can be,
You withdraw the suit.
that can be.
In the
right.
meantime, the petitioner may be directed to pay the regular monthly fees because
The regular.
No,
fee
regular,
has
then
been
disconnect. You have a power to disconnect if they are not
I
paying.
am for regular fee, I am ready
Regular
to pay,
bills are not
lordship.
being
They
paid,
have not
lordship.
installed the meter also.
I'll do one thing.
Lordship.
I will dismiss your appeal, the proceeding.
At least they may be directed to.
No,
install
no,
the
no,
meter,
no.
lordship,
Let me pass an order. Let me dismiss your appeal.
Lordship,
The
can
entire
we
order,
consider
the order should not have been passed. And under such circumstances, the suit was misconceived. However, the petition plaintiff would be at liberty to withdraw the suit and thereupon prepare an appeal before the authorities within 20 days. Until these 20 days, no disconnection. I think that is a fair for both of them.
that I,
Type of suits unnecessarily.
and the lordship.
This is an
kindly
application
be
under
given
Article
that
227
the
of the
appeal should be prepared,
Constitution
lordship,
challenging the order dated 23/2/2024, passed in Miss Appeal number 21/2022. From a perusal of the said of the impugned order, it reveals that that though in the suit the dispute arose in respect of an amount of 94,708 pertaining to the bill dated 4/8/2021 for the period from 2/7/2021 to 1/8/2021. But the learned First Appellate Court, while adjudicating the said appeal, had directed the APTCL authority to submit the electricity bill from June 2018 to the date to the date of to the present date, and it was found that the petitioner herein, who was the appellant, was liable to pay an amount of rupees 1,82,140, which includes the bills of the disputed period as well as prior to June 2018. Under such circumstances, the learned appellate court, taking into account that there was no dispute of an amount of rupees 1,44,520, directed the petitioner, who was the appellant therein, to pay the said amount in installment per month at rupees 15,000 along with the current demand of the bills. Further to that, the appellate, at the request of the petitioner for replacing the electric meter, the respondent, APDCL, was directed to take necessary steps for replacing the electric meter of the appellant. This court, upon perusal of the impugned order, is of the opinion that the same does not require any interference from this court under Article 227 of the Constitution. More so, in view of the provision of Section 41H of the Specific Relief Act 1963, which categorically mentions that where equally efficacious relief can be and certainly be obtained by any other usual mode of proceeding, except in the case of breach of trust, no injunction should be granted. Taking into account the above, this court is not inclined to interfere with the said order dated 23/2/2024. Be it as it may, this court, upon hearing this court, have also taken note of the submission of Mr. Yes, your name, so and so, appearing on behalf of the APTCL, who submit that there is a, what is that forum name?
Consumer Grievance Redressal Forum, Lordship.
Consumer Grievance Redressal Forum, wherein the petitioner ought to have instead agitated instead of filing the suit, which gives an equally efficacious remedy to taking into account the above. This court, however, observed that till for a period of 20 days from today, the judicial authorities shall not disconnect, giving the disconnect the electricity connection, and the petitioner would be at liberty to withdraw the entire suit proceedings and approach the said forum if so aggrieved with the amount.
Can you say up to
With the
one
above the
month,
instant
Lordship?
proceedings, then
Can you say up to 1 month? Lordship?
15 days, 15 days going.
Kindly consider. Lordship.
15. You have to approach, go and file. It is a form. It is just a form. You file it. They give a stay also there.
Attempt 3.
Lordship, three, same lordship, the judicial files an appeal lordship and challenging the miscase order. In
You have
that,
challenged it.
We challenge it,
This order,
yes, against that order, they have preferred this revision, Lordship.
taking into order, taking the learned counsel, Mr. So-and-so, the learned counsel appearing on behalf. Oh, what is that? The same order has been passed.
Same order, Lordship.
miscase order lordship, they have challenged before the district judge lordship. In that case also, the same order was passed.
So both the orders can be same,
Yes.
one order.
Lordship,
So both the appeal stands disposed of, huh? Both the revision application.
lordship,
Lordship.
that when as 20 days. lordship.
20.
Idea.
Attempt 4.
Yes, what is this?
May I please, your lordship, your lordship, in the appellate court, I file a petition under order 41, rule 25, read with chapter 151, CPC. From framing of the additional issue. What happened is that my.
What is order 41 rule 25? Order 41 rule 25 is a power vested upon the appellate court to transfer, to remand the proceedings by remand the proceeding.
Your
Yes.
lordship, to frame the additional issue.
Additional issues, what is these additional issues? Is it done under order 41 rule 25? I hope I have not forgotten the provision. Order 41 rule 25 is for remand. Yes. Where the appellate court may frame issues and refer them for trial to court whose decree appealed from. Where the court from whose the decree appealed from is prepared has omitted to frame or try any issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon merits, the appellate court may, if necessary, frame an issue and refer the same to so and. This can only be decided at the final decision of the appeal, not prior to that.
Your lordship,
Hmm.
what happened actually this case, it is the entire case raised with the additional issue. But in the WS, I specifically stated, who can be so whether there is a misjudgment and done that. What happened, it is a very tense case. I am staying, my defendant are
Mr.
staying.
Talukdar, we will do one, no. Whether that additional issue should have been framed or not
Yeah.
can only be decided at the final decision of the appeal, not prior to. The law is very clear. You see there, what are the powers of remand? Order 41, rule 23. That is keeping the appeal pending. On one issue, it is being asked. See, order 41, rule 23. Remand of the case by the appellate court, where the court from whose decree an appeal is prepared has disposed of the suit upon a preliminary suit point. If the suit has been done, it has to be remanded. Then remand in all other cases, order 43, where the court from whose decree an appeal is prepared has disposed of the case, otherwise then on a preliminary one, the decree is reversed in appeal and a retrial is considered necessary, the appellate court shall have the same power as is under 23. Then 25, where the court from whose decree the appeal is prepared has omitted to frame or try any issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon merits, The appellate court may, if necessary, frame issues and refer the same for trial. So this power of remand has to be exercised at the final decision of the appeal.
Your lordship, what happened? It is the very, if the entire case raised with this issue, in the trial court, in the W specifically stated, whether that there is a misgender and non-gender, specifically stated in the written statement also. What happened? It is a very strange matter. I am, the defendant are staying in the Borgao, is a separate revenue village. Your lordship, a separate revenue village, and title sweet land is at Dhupguri. Dhupguri. There, in evidence in the record, specifically admitted the plaintiff that there another person also staying there. They are separate revenue village. We filed I filed this petition with a specific proof. Your lordship may kindly peruse the petition. It is well, your lordship 101. Kaubura president, they are certified. They are residing a government land. Government land. What happened? In this case, the defendants.
Mr. Talukdar, kindly listen. A issue having not raised, not being framed therein before the trial court, you could have very well taken steps under Order 14, Rule 5, which you have not done. Most probably, you have not taken. You did not file an application before the court there, before the trial. Now, thereupon, an appeal has been filed. An appeal has been filed, thereby you are not precluded from raising that issue under 105. You have therefore raised under 105. Now, the appeal is being heard as to whether the suit should be dismissed on non-joinder of necessary parties. So, if the court considers that, yes, that is a vital issue out there, so the case may be remanded. But when will the court remand it? The court will remand only at the final hearing of the appeal. Could the court decided it prior to that? No.
No, what happened? Actually, at the trial court, hesitate several times. There is in the records. Hesitate. This issue, only for this issue. The entire case is raised with this issue. Well, we are reciting a separate revenue village in a government land. There, disputed land is a Miadi land. Periodic patta land. We are not staying in the periodic patta land.
When is the appeal fixed for hearing?
Fixed for now, hearing stage is going on.
When is the appeal fixed for hearing?
The appeal fixed for hearing.
When?
The 5 March, the last day was fixed for hearing.
So, hearing complete?
No complete. No, not yet complete.
What has happened till date? What is the present position? What is the next date?
No.
What is the next date in the appeal?
Last day was 5.
Mr. Talukdar, you find out what is the next date in appeal. We'll take up the matter after some time. Okay? We'll take it after some time. Get me the date of appeal.
Implemented item 53 and 54.
Yes. But you also want a transfer. Mr. K. A. Mojumdar also wants a transfer in the same place in Silchar.
My case justify wait for transfer for him that of case filed by the wife. Because I said wife, I cannot participate in the proceedings personally.
You have a flight directly from there to Guwahati and Guwahati to Silchar directly flight. Why don't you have it in Silchar? They want it in Silchar, have it in Silchar. They want it in Silchar, na? Where is that? Where? He wants it in Silchar. Silchar. So have it in Silchar. Silchar is near it. Why do you have to go another 71 kilometers to Korimgat?
Karimganj, my permanent residence is Karimganj.
So what? But you don't stay there. You stay in Dubai.
It is true.
Who is appearing for the other side? Oh, he was not there that day. We do one thing with the transfer all proceedings out there to Dubai. Let it be under one court.
My alternative prayer is also there. Alternative prayer is
You want the transfer of what proceedings?
proceedings filed by the wife lordship. Is there a-
Wife has also filed the proceedings.
Yes, I filed a divorce petition
Ah.
before the district judge Karimganj.
Ah.
And she filed, she filed divorce petition, he withdrawn it. Now she has filed a petition for the petition of conjugal rights.
That is number.
Uh, It's number 313, civil case number
FC Civil Case 313/2023.
23.
This is pending before the principal judge family court. Silchar. Now, you have filed a divorce case which is at Karimganj.
Karimganj.
So I think both should be there together. Okay. Both the transfer applications being transfer petition number 21/2024 as well as transfer petition number 4 of 2024 are taken up together for disposal, taking into account that both the proceedings are interconnected between the husband and the wife. The petitioner in the transfer petition number 4/2024 is the husband who have sought the transfer of FC Civil Case number 313/2023 pending in the court of the learned Principal Judge Family Court Kachar Silchar to the court of the learned District Judge Karimganj. The petitioner in transfer petition C number 21/2024, who is the wife, have sought for transfer of title suit divorce number 154/2022 instituted by the husband from the court of the learned District Judge Karimganj to the Principal Judge Family Court Kachar Silchar. It is an admitted fact that the husband, that is Sri Samarkanti Paul, BAUL, presently resides at Dubai, UAE. However, his wife, that is Srimati Suchitra Ball, resides at Silchar. Taking into account the convenience of both the parties and also upon hearing the learned counsels for the parties, this court is of the opinion that the question of transferring FC Civil Case number 313/2023 pending in the court of the Principal Judge Family Court Kachar to any other court does not arise. Consequently, transfer petition number 4/2024 stands dismissed. However,
my alternate prayer was there to transfer it to the petition.
cannot be for transfer of the
Page 9.
alternate pay is what?
For transfer the divorce petition, my petition to put the court of petition.
The prayer for the prayer in for transfer of FC Civil Case number 313 2023 pending in the court of the learned principal judge family court Kachar Silchar is rejected. Full stop. This court also take note of that in transfer petition number 4/2024, there was also a prayer for transfer of the petition filed by the husband to the court of the principal judge family court, Kachar Silchar, which is also the prayer in transfer petition number 21/2024. So taking in that view of the matter, this court allows the transfer petition C number 21/2024 as well as also the alternative prayer in transfer petition number 4/2024, thereby transferring title suit divorce number 154/2022 pending before the court of the learned district judge Karimganj to the learned principal judge family court Kachar Silchar. The learned district judge Karimganj is hereby directed to forthwith upon receipt of a certified copy of the instant upon a receipt of a copy of the instant order to transfer the case records of title suit divorce number 154/2022 to the court of the principal judge family court Kachar Silchar. The registry is further directed to take appropriate directed to also intimate the court of the learned district judge Karimganj as well as the learned principal judge family court Kachar about the instant order. Both the parties are directed to appear before the learned court before the court of the learned principal judge family court Kachar on 5th of April. 5th of April. On 5th of April, 5th or 8th. Should I make it 8th? 8th of April. On 8th of April, so that the proceedings in both title suit divorce number 154/2022 as well as FT civil number 313/2023 can be proceeded with by the learned principal judge family court Kachar in accordance with law. Both the petitions can.
Item 5 and 55.
Yes, what is this?
Our attempt would be to close this matter forever, Lordship.
Huh?
This matter.
Huh?
because
You want
there is
to
a long
close it
pendency of
forever?
case From 1992,
Very well.
and only few lakhs rupees were to be given by the state of Assam.
Huh.
And today it is a hoping amount of 58 crores.
Then?
70 crores already paid. The rest 41 crores I have with me, Lordship. I'm ready to give it today itself. So if they are agreeing to for closing it, then it can be closed.
Yeah.
Then you file a petition both.
Our
Yeah, Lordship
submissions
has
may be
according-
No, Mr. You see, this is after all, this is a civil proceedings.
Sure.
You file it during the course of the day, make it a short petition, file it, ask both the parties and file it, we'll take it up today itself and dispose it off.
Lord.
Just file it, a
Lord.
joint petition
Lord.
that you are agreeable to this and the matter stands for
Matter
it.
stands cleared.
You file it, just the affidavit is required.
His client will come. Lord. Okay.
You get it done and we'll take it up at the end of the day.
Highly obliged.
Because without that, you may have a lot of difficulties.
Lord.
In a REIT is different, is a very different thing, but not in a
Because in the REIT also they are paying the same.
understood. But REIT is okay, but here also
Okay.
this floor,
Will do it, Lord.
we'll take it up whenever you file.
Giving all details of the check number.
Huh?
giving the details of the check number.
Yeah. So I'll close it on that page.
Highly obliged.
Item 6,
58. Admit, no, take it to method. Admit, no. Yes, what is this?
Lordship, in this case, I have challenged the order passed by the London trial court. Lordship setting aside abatement and granting the plaintiff to substitute the legal expert. Earlier, the same petition was rejected, and again, same petition was filed. Therefore, the same proceeding,
Where is the order?
earlier order, your lordship will find page 37. Annexure 5. There were two plaintiffs, lordship. Plaintiff number 1 died.
9/12/2005. Then
Thereafter, lordship, annexure 6, page 38, they filed an application under order 22/2/92 CP for substituting of the same plaintiff. Along with another application, lordship, that is annexure 7, page 44. Above named petitioner substitution under section 5 of Limitation Act for confidential public. That was allowed.
who is appearing for the respondent? Name shown.
We have filed our objection, lordship. Thereafter, by impugn order 53.
No, he also. What type of order is being passed? You are appearing for madam? For whom?
I'm for the government lord.
You are for the?
Government lord.
Who is respondent number
Mr.
3?
B.K. Barua.
Huh?
Mr. B.K. Barua.
Okay.
As per number 6, 7, and 8, I am appealing.
The lordship got citing cases stated that the sector law is self clear of it. Plaintiff
But
must
unless this order is not challenged,
prosecute
9/12/2019 is challenged in any other forum. The abatement which had been, the suit having abated
in respect
as regards the defendant deceased number, plaintiff number 1, nah,
plaintiff number 1.
cannot be regular. That's it.
Sorry.
Hello. None has appeared, and their name has been shown, they have been
Yes,
served.
B.K.
Yeah.
Barua.
The instant petition under Article 227 of the Constitution. Yes, why are you filing under 115? The difference between 227 and 115 is lost. How will 115 lie? Tell me.
It was post of that. That was post of that.
Is it your petition? Then how will you maintain 115?
Number
So we dismiss it on that ground? Let them fight.
number
This is an application under section 111, 115 of the Code of Civil Procedure challenging the order dated 5/1/2022 passed by the Munsif number 2, Learned Munsif number 2, Dhubri, in title suit number 402/2014, whereby an application being petition number 884/2020 under Order 22 Rule 9(2) of the Code of Civil Procedure 1908, for short the code, as well as the petition number 885/2020 under Section 5 of the Limitation Act 1963 was allowed. Full stop. Though the instant proceedings have been filed under Section 115 of the Code, but taking into account that the said proceeding, that the instant proceedings ought to have been filed under Article 22(7) of the Constitution and not under the provisions of Section 115 of the Code. This Code, for the interest of justice, converts the instant proceedings to a proceedings under Article 227 of the Constitution. From the record, it is apparent that the plaintiff number one in title suit number 402/2014 had expired on 27/9/2018. Thereupon, on 6/2/2019, an application was filed for substituting the legal representatives of the plaintiff number one. However, this application, being petition number 676/2019, was rejected by an order dated 9/12/2019 by the Learned Trial Court. And it was further opined in the said order that the suit would abate against the deceased plaintiff number one and shall proceed at the instance of the surviving plaintiff. Full stop. Almost immediately thereupon, on 4/2/2020, the plaintiff filed another application being petition number 884/2020 for setting aside the abatement under Order 22 Rule 9(2) of the Code, and also an application under Section 5 of the Limitation Act 1963 for condoning the delay in filing the application for substitution. The said application, the Learned Trial Court, by the order dated 5/1/2022, although opined that there was no specific ground in the petition under Section 5 of the Limitation Act for which the delay must be condoned. But for the end of justice, allowed both the application for condoning the delay as well as for setting aside the abatement by the impugned order dated 5/1/2022, for which the instant proceedings have been filed. This court have heard the learned counsel appearing on behalf of the petitioner, as well as the learned counsel appearing on behalf of the respondent number 6, 7, and 8. None has appeared on behalf of the respondent number 3, 3B, 4B, 5B. None has appeared on behalf of, yes, none has appeared on behalf of the respondent number 1A to 1E, comma, 2, 3B, 3, 4B, and 5B. This court, having perused both the orders dated 9/12/2019 and 5/1/2020, is shocked and perplexed to take note of that when, by the order dated 9/12/2019, the application for substitution was rejected, and there being no further proceedings against the said order dated 9/12/2019, how the learned trial court could have allowed the abatement, allowed the setting aside of the abatement and condonation of delay by the impugned order, that too, even after arriving at the finding that there was no specific ground in the petition under Section 5 of the Limitation Act for which the delay must be condoned. Taking into account the above, this court is of the opinion that the exercise of the jurisdiction of the learned trial court by the order dated 5/1/2022 is on the face of it suffers from exercising jurisdiction not conferred upon it by law, as well as also exercising jurisdiction with illegality and material irregularity, for which this court sets aside the order dated 5/1/2022. Consequently, the stay order dated 5/5/2022 passed by this court stands vacated, and parties are directed to appear before the learned trial court on 3rd of April 2024. This court, however, before parting, would like to observe that the setting aside of the order dated 5/1/2022 by this court by the present order shall not, however, preclude the representatives of the respondent number of the representatives of the plaintiff number 1, legal representative, to avail such action as deemed fit as proper, avail such action as permissible under law against the order dated 9/12/2019 if so advised.
Item 7.
order passed the list and itu लिखी सुना है.
Wait, please, Your Honor.
Yes,
So it's a revision matter against an order passed in appeal rejecting our injunction matter. This is 2022. The facts of the case are like this. And the
who is the plaintiff?
I'm
Well done. What did you ask for?
basically my lord, our predecessor matter, that is the father, he had a plot of land measuring 2 bigha, 4 kata, 6 lesser. So in the year 2017 matter, we while visiting the circle officer, we came to see that there are several entries being made in the record of rights. Within several changes were shown to have been executed. So thereafter, my lord, we have preferred this to praying for declaration of title as well as permanent injunction as well as cancellation of the sale deed.
Just 1 minute.
Yeah.
What are the delete for? Now the defendant who are accepting the under such circumstances, the defendant number 4A to 4F are required to be restrained permanently from dispossession. What is the prayer? For decree declaring that the plaintiff has right title and interest
Yes.
over the suit land, for
Yes.
decree declaring the defendant number 4-1 to have no legal right, decree that the that are false and for decree for cancellation, for decree of perpetual injunction, for dispossessing the plaintiff. You are in possession.
Yes.
Now what is the order?
The order, my lord, relevant portion.
Wait. First of all, why have you not enclosed the injunction application before this court?
My lord,
You've enclosed?
yes, my lord.
And what
Page
is the
number
written statement file?
49. Yes. Right here, written.
And they have no knowledge to ensure during the lifetime of the person had purchased the land. Where is the injunction application?
My lord, at page number 49.
It is therefore prayed that your honor would be pleased enough to pass an interim order so that the opposition could not dispossess from the suit land till the disposal. Then, what is the order passed?
My lord, order, my lord, is at page number 50.
I've heard for granting them a then appeal.
Yes.
Yes, who is for the respondent?
I am for the respondent.
You are for the plaintiff.
I am for the defendant numbers 4.
Now, the question is, you are saying that you are in possession. You are saying you are in possession.
Thing is that, my lord, how they have claimed their title. They
I'm
say-
not concerned.
Yeah.
What is your injunction? Mr. Counsel,
Yeah.
your injunction is not to dispossess you.
Yeah.
That presupposes you are even in possession.
Yeah.
He says that he is in possession. So I'm asking, let both the parties maintain the status quo.
Yes. But-
Or I can do one thing, ask both of you to get out and give it to somebody else. What do you want? Ask the DC to take you over. You want the possession?
Yes.
You also want the possession. Remain possession. It is what is okay. A dispositive unnecessary.
Look, we are only agreed by some of the findings that there is confirmation of position to have been asked. But the thing is that, man, in a case where the plaintiff have position, but the title is clouded, man, why would my lord the plaintiff seek to have to seek a declaration regarding confirmation of position? If they were not in position, my lord, then my lord perhaps recovery of position ought to have been asked as ancillary. But my lord, how can if plaintiffs are really admittedly in position, man, why would my lord the plaintiff would have seek?
So your all these things shall not affect.
Yes.
The observations made here shall not affect. Isn't it? This is an application under Article 227 of the Constitution, challenging the order dated 22/3/2022, passed by the learned District Judge Dubri in Miss Appeal number 4/2019, whereby the order dated 23/7/2019 passed in Miss J case number 76/2018, arising out of title suit number
43.
43/2018 was confirmed. It reveals from the record that the petitioner herein had filed the suit, being title suit number 43/2018, seeking declaration of their right, title, and interest over the suit property. Described in the schedule to the plain for cancellation of various sale deeds, semicolon, for correction of the record of rights and for permanent injunction. Along with the said suit, an injunction application was filed seeking a ad interim temporary injunction against the defendants who were the opposite parties, not to dispossess the plaintiff oblique the petitioner from the suit land till the disposal of the title suit. This court have duly perused the injunction application, wherein it is the specific stand of the petitioners that they are in possession of the suit property. Suit land. And in paragraph number 8 of the said injunction application, it has been mentioned that the opposite parties therein were threatening the petitioners to dispossess them from the suit land. To the said injunction application, a written objection was filed by the opposite parties, who are the respondents herein. Stating inter alia that the opposite parties have been in possession of the suit land since 11/9/1985 as the lawful owner. And as such, the question of threatening the petitioner and reasonable apprehension of dispossessing them from the suit land does not arise. This aspect of the matter could be seen from paragraph number 13 of the written objection. Pursuant thereto, the learned trial court passed the order dated 23/7/2019, thereby rejecting the injunction application In the said order, the learned trial court had observed that how can both the parties be in possession of the suit land at the same time? And as the court was unable to know as to who was in possession of the suit land, the prayer for temporary injunction was rejected. Being aggrieved, the petitioner prepared an appeal before the court of the district judge Dhubri, which was registered and numbered as Miss Appeal number 4/2019. Whereby the learned first appellate court opined that the plaintiffs who were the appellants therein failed to prove the prima facie case that they were in possession of the land either by cultivating or through implied possession. The learned first appellate court further went to the extent of opining that if the appellants at all were possessing this land, why the appellants did not, as plaintiff did not, seek the relief of confirmation of possession as an ancillary relief. It was further opined by the learned first appellate court that the land in question has been the subject matter of dispute since 1970. And the respondents have been enjoying the land since 1985. And respondents have claimed to be enjoying the land since 1985. It is on that account the appeal was dismissed, thereby confirming to the judgment order dated 27/3/2019, passed by the learned trial court. Being aggrieved, the instant appeal has been filed, and the instant proceedings under Article 227 have been filed. This court, having taken note of the relevant pleadings before the trial court as well as also trial court, as well as the impugned orders, find that both the parties claim to be in possession of the suit land. It is well settled that the status of the property as on the date of filing of the suit is required to be maintained. Under such circumstances, the question, under such circumstances, the learned trial court or the learned first appellate court ought to have directed that the status quo as regards the possession ought to have been maintained, ought to have directed that the status quo as regards the possession to have been maintained, so that during the pendency of the suit, there is no further multiplicity of proceedings, which having not been done, the well-settled principles of passing of an injunction for consideration of an injunction prayer have been disregarded. Consequently, this court therefore disposes of the instant proceedings, directing both the parties to maintain possession over the suit land as on today, till the disposal of the suit. With the above, the instant proceedings stand.
Lordship, one more prayer. May your lordship kindly observe that the trial court may not be influenced by this order,
Which one?
at least CRP order.
Why?
While adducing evidence, it may be decided.
Have I ever said that he is in possession or you are in possession? Then the trial court will decide. I can say one thing. The trial court should. This court also finds it very relevant to observe that orders passed in interlocutory proceedings are only for deciding those interlocutory proceedings which arise during the are only for deciding those interlocutory proceedings. And such orders which have been passed shall not influence the learned trial court in the disposal of the suit.
Item 9 and
Hello.
10.
Yes, why? Two matters.
Two orders, two different orders passed under the impugned order, your lordship will find at page 63.
Hmm?
Although it's page 63,
Who filed the suit?
suit is by the
Filed by-
respondent. By
You
the
have filed the suit. Then what happened?
Order 7, Rule 11, my lord, my
Who
petition
filed
was-
order 7 rule 11? You have filed.
And although it's a very longish order, the operative portion, my lord, various provisions have
You
been
filed
recorded
order 7 rule 11. For what? Why have you filed?
for
Where is
rejection.
the suit? Plain?
Plaintiff is that it's
Let
page,
us take up 50.
my lord, the page 34.
34.
Mal.
Okay.
But there are two aspects.
Huh?
If I may just indicate the basic fact. What had happened was we had executed an agreement for sale pertaining to a particular plot of land in Northwest. And that itself was also contingent on certain events. In any case, but after the agreement, the land was acquired by the government for construction of the ongoing bridge that is happening. So it became impossible. He was aware all along.
It became?
The land itself in question for which the agreement was executed, that was acquired by the government for construction of the bridge, which is still going on. Now he was fully aware of this, and he files a suit with seeking twofold relief. He is seeking specific performance. At the same time, one of the prayers he is making is to restrain me from withdrawing the awarded amount. Now, that means that he is fully aware of impossibility of the event, the performance, and those are born out of the plaintiff itself. If your lordship may kindly, the agreement itself will
There's
So-
only one suit? There's only one suit?
two suit.
Why there are two suits?
The other one, there was a relinquishment deed, and your lordship is aware there has to be some title in favor of the my lord, in favor of whom the relinquishment deed is being executed. There is only merely a agreement for sale. That one raised. Now, all these are born out of the plain itself. And with my limitations, my lord, as I have understood, Order 7, Rule 11, my lord, on a meaningful reading, if it is born out of the plaint itself and the document, it's a clear case for rejection.
So you mean to say you entered into an agreement with him for sale of some land. That land has been acquired. Has it been acquired?
Yes.
Acquisition done.
My lord, in fact, that bridge is getting constructed, as your lordship is aware.
It is okay, but has the land been acquired?
Yes, yes, yes. Yes.
Award passed?
Yes.
Award passed. Then the question is, who is entitled to the amount? He can't sell it.
He can't say it.
His title is gone with the
Yes.
acquisition. So the question is whether you will be entitled to the amount
Yes.
or apportionment of the amount, or he is being.
Yes, my lord.
So, Mr. Where do you have to go?
So we are not selecting the acquisition or entitlement of the account.
Where do you have to go? You want the money.
Yes, yes, yes.
Where will you go?
Before the acquisition officer. But the case as submitted is not done. If your lordship.
When was the acquisition done?
In the year 2019.
2019. And when was the agreement entered into?
2017.
2007. In the year 2009, was it done under which act?
My lord,
Acquisition?
acquisition, your lordship.
39. 39.
No. Acquisition under which act?
This is the 1964 Act.
64.
Correct.
Section 6 notification issued under what? Or section 9 is notification, when was it issued? This was not a case of requisition. It was a case of acquisition. So it has to be either section 6 or section 9. Now, the moment the notice is issued, thereupon, does he have any authority to enter into an agreement?
No, but the agreement was
Now, why
entered.
should I decide? Or the civil judge decide? Why not the district judge decide? Why you are going into the lower forum?
But my lord allow me then if I learn it.
No, understood. I am asking you a specific question.
Because my case is for breach of contract.
Fantastic. You want the money?
Yes. And breach of contract, the jurisdiction is of the civil court.
What is your breach of contract?
Breach of contract is that they refused to perform when the land was acquired. Now, my lord, if my lord comes to the plaint first, page 34 annexure 4. Or prior to that, your lordship is to come to the petition which has been filed for rejection of plaint.
No, I don't go by the rejection.
So the
Let
submission.
us see where is the land. The father of the plaintiff was an occupancy tenant under the predecessor in interest of the defendant in respect of part of and after the plaintiff. Yes.
My lord has gone to the plain. Now, the land pertains is a exenia plot of land. That is,
Huh?
it's an exenia annual patta land. The distinction has to be drawn because an annual patta land, the transfer and the annual transfer with regard to a periodic patta is different. Because this Honorable Court has, in Suren Singh judgment, has already held that even an annual patta can be transferred to an unregistered deed. Now, if you
To an
are
unregistered deed.
yes,
Show me that.
Your Lordship.
How can a property be transferred by way of an
Your Lordship,
unregistered deed?
it has been stated the limited right which has been confirmed by an annual patta can be transferred by an unregistered deed. This has been held in 2016 5 GLR 228.
Show me. Single way.
Yeah, single bench.
Okay. Who can write over a property?
Your Lordship, because
Where are you saying it can be transferred by way of it?
Your Lordship, in this case, there was an unregistered sale deed executed in favor of the petitioner. And in pursuance to that unregistered sale deed, when the petitioner concerned approached the revenue officers for registering his name in the revenue of records, the revenue officials refused to register his name. And in fact, cancelled the patta and converted the land into the government land, which proceedings were challenged before the revenue board. And ultimately, revenue board also held it that since there is a no registered instrument, so accordingly, the matter was, the appeal was dismissed and the matter was settled before the Honorable High Court.
Yeah.
Thereafter, Your Lordship, para 13. The transfer of the annual patta land for the unregistered sale deed is not disputed by the transferor, but their appeals before the revenue board was founded on the submission that they had not executed any valid sale deed. But if you consider the limited right available to an annual patta holder, in the absence of any provisions with regard to transfer of such land, the transactions can certainly be enforced against the transferors, and to this extent, the right claimed by the transferors on such annual patta will stand extinguished. The division bench was followed. So ultimately, Your Lordship, this judgment was passed on the basis of an order of the Honorable Division Bench. But
No. The division bench says something else. You see, the proposition which was there before the division bench and all along has been that you can sell an annual leave.
Yes.
An annual patta, although as per the definition contained in, I think, Rule 1B or 1C or 2B, categorically mentions that an annual patta cannot be transferred. But on various judgments of this, our High Court have held that yes, the right can be transferred and annual patta will continue till a notice is not given for non-renewal.
Yes.
That has been settled from 1950.
Yes.
It never says that a transfer of an annual patta can be made by an unregistered document.
Your Lordship, but in this judgment,
That was here what it does. Therefore, you see paragraph number 14 or 14 or 15. Kindly see. Though the unregistered sale deed, the transferee acquired no better right than what was held by the estate under so and so, but such right, even though limited, can certainly be enforced by the transferor against the transferee. So it will be here, but it can't be recognized.
my lord,
There cannot be a sale. There cannot be a sale. When how can a right over a property, immovable property of a value more than 100 can be transferred? This is completely per inquiry ability. So,
my lord.
anyways, we are not on that point. Now coming back to our point.
So the present suit was anyways for agreement for sale based on the agreement for sale in respect of an annual patta land. Now, when the land was we were the occupancy tenant in respect of the land. The total land was 6 bighas, 4 katta, 14 lakhs. In the concern.
Annual patta land?
Annual patta. My lord, the Jamavandi, my lord will find at page 24.
Okay. Then?
So out of which they came into a settlement with us not to go for acquisition, means like file an application under section 23 of the Assam Temporary Settled Areas Act. And we will do one thing, we'll give you this property and we'll also give you the another CRP, which is 2 bighas. So 4 bighas were given to us, out of which they agreed to give, means like this property, subject matter of the CRPI of 50, they agreed to transfer it on a consideration amount of rupees 13 lakhs. We paid 12 lakhs to them. Subsequently, Your Lordship, the agreement was such that the property has to get converted into an annual patta for deriving a valid title upon the party. Now, before submitting further, in this case, Your Lordship, the defendant side appeared, they filed their written statement, they also filed their counterclaim. Now, when they filed their counterclaim, they challenged that the agreement is forged, means there has been tampering and there have been forged in the agreement concerned. Because, Your Lordship, why I am submitting this is we are dealing with an application under Order 7 Rule 11D. And prima facie, what it discloses from the submission is that they say impossibility of contact means the plaintiff does not disclose any cause of
You have a
action.
counterclaim.
Yes.
You have a counterclaim. How can you then maintain this? You want his suit to go and your suit should remain. My goodness. How is it possible? Tell me. You want his suit to be rejected and your suit should remain. That's it. It can't happen both ways. That is the most serious thing which you have done. How can you do that? At the end of the day, both of you are not going to get any benefit. Both of your cases, you have to get the money. Money, I think, may be stalled somewhere with the state, and the state having now tendered it, there is no accruing of any interest.
My lord, that is.
You are, from your case, it is seen that you are a person interested. Because you in view of the 1964 Act, the same meaning has been given as per the 1894 Act. So you will be therefore be a person interested. He is also claims to be a person interested. Both of you therefore require to file an application seeking apportionment or that you are the only owner.
Yes,
And to get the compensation.
my lord,
As of now, you kindly see, asking for a specific performance
my lord,
would not give you.
my lord, that proposition would have been considered, and perhaps if I was the owner, then the suit was not meant. But I am not the owner.
You don't need to be an owner.
My
The
lord,
possession
my lord,
would also be a person interested.
by virtue of the agreement for sale, I do not have any interest to claim before the authority concerned. I cannot raise section 54 of the Transfer of
You are not
Property Act.
before the authority concerned, you are before the district judge, who is going to decide whether you are a person interested. A possession, kindly see what is the meaning. Mister, kindly see what is the meaning of the person interested. See the Land Acquisition Act.
My lord, if I
No, don't. See what is the Land Acquisition Act. Necessary. Both of you are
my lord,
fighting.
the where I am, your lordship, the submission on behalf of the defendant or the contention before the court concern was with regard to rejection of plaint on the ground of impossibility of contract. Now, my lord, I am just one thing I would just like to submit.
The counsel, the ground which he has taken is not there. That cannot be the ground for rejection of. That cannot be the ground because of the fact that what you are asking is for damages.
Yes.
So
And
under
refund of
such
money.
circumstances, for breach of contract, you are asking for damages. So that cannot be the point.
My lord,
But the question is, good sense should prevail between both of you
my lord, I agree.
instead of fighting litigation unnecessarily.
My lord, we have also prayed for refund of the refund of the money if the performance is obviously refused.
Mr. Counsel, why you are not looking into the definition of person interested? Without knowing all these things, you are making the submission.
My lord, if then let this matter be taken up tomorrow.
Why?
I
You don't have a
will.
book.
No, no, my lord, I will come prepared on that
Not
issue of
necessary.
interested person. My lord, grant me that liberty.
Why do you need? I'm saying it to you. Why do you need?
My lord, I also need to study it on that issue.
Why do
Whether
you
the
need to
interested
study?
person will include a person of such. If it is so,
Absolutely, it is there. That is why I'm saying you both of us are fighting unnecessarily before that. You want the matter to be pending before the trial court. Very well. Have it matter. Have another 4 matters pending. File another 3, 4 suits. But is it going to survive? Because at the end of the day, the state is going to have the money with them. You are not, both of you are not going to get the interest. The interest which you are otherwise entitled to at 9% and 15%, you're losing both of you. Therefore, the question is whether whether you are person interested. If you are person interested, why don't you fight it out? The same questions which you are arguing, the best question has to be argued for them. $1894. The expression person interested includes all persons claiming an interest in the compensation to be paid on account of the acquisition of land under the act, and a person shall be deemed to be interested in the land if he is interested in any easement affecting the land also. This is the broad definition of a person interested.
Well, grant me some time. I just need to study it. Whether
With cost, not ready.
my lord,
10,000 rupees.
my lord, tomorrow. Or at 2, my lord, at 2.
At 2, then it is 10,000. At tomorrow, it is 25,000.
My lord, I need to I'm humbly praying that need to go through that provisions of law. Nothing.
Why do you need to go through the
Because that
provisions of
interested person.
law? First of all, you are doing a matter without knowing the provisions of law.
No, my lord,
Yeah,
presently.
I thought you are a better lawyer for that.
My lord, just accommodate me for a day.
Why?
My lord, I'm just asking because the matter in hand is such. Just
You have a stay? You have a stay?
Yes, sir.
Okay, let us stay continue. We'll admit both the petitions. Let it come up for hearing in the usual. Both are not interested out there. Why should taking it upon hearing both the learned counsels for the petitioner as well as the respondent, this court is of the opinion that both the matters requires an elaborate hearing for which both the revision application stands admitted to be listed for hearing in the usual court.
May I pray for a date?
No date. No, I think it will be in 2029. Listed sometime in the month of April 2029. No, not. Unnecessary, both of you are doing at it.
11.
Yes, what is this?
This petition has been brought, my lord, against the order. Lordship will find page 199, the impugn order.
Page 200.
190.
Huh?
190.
Start from 200.
Yes. Sir. The petitioner is the my lord defendant, and plaintiff filed the suit for declaration of right title interest and cancellation of sale deed. Petitioner is the purchaser, my lord, purchased a plot of land, and they have paid for also injunction. And injunction was not granted, but status was done. But the order was passed against the order 151. Petition was filed for allowing the petitioner to repair the house. And that was granted, but
Yes, who is appearing for the other side
last date also, they are not,
has been shown, the
Okay.
names of the councils have been shown in the court list.
no man.
No,
No need.
is
Last,
anybody appearing?
Last date, my lord.
Huh?
It was directed to reflect the
What is
name.
the item number?
Number 11.
Yes, not. Nobody's name has been shown. Is anybody appearing? Has any wakalatnama been filed? T Islam? You are T
No, my lord. Islam was also my lord. I'm,
Islam is with them.
yes, my
Has anybody appeared? For S-Nath? You are S-Nath.
lord.
There are more persons who are appearing for a year. The names of the councils have been shown. Since the wakalatna has not been filed name. Okay. None has appeared on behalf of the respondent.
Yes, my lord.
Is the
Also,
service complete?
service completed, my lord. Service
Names
completed,
of
my
the
lord.
learned has been
Dated
writing and date for
12, 10,
admission,
23.
date for admission, name of the council
12, 10, 26.
upon the
They are not interested, my lord. They are not.
where is the service complete about the respondent?
My lord, official note, my lord, 12, 10, 23.
Huh? 12 10 2023.
Yes, ma'am.
Well, 10 2023, no. Service upon the respondent is not complete. As per the office note that the process has been due, none has appeared. The office note dated 10/5. 5 pertaining to trustee has been filed at the service report. The process has been why the trustee is only as regards 6 to 12, not against the others. Others are the main defendants.
Yes, madam.
Then what about 1 to 5? 1 to 5 service is not complete. Take step. The record from this court have duly perused the record, and from the record it does not reveal that the steps upon the respondent service upon the respondent numbers 1 to 5 is complete. So this court have also taken note of the affidavit of service, which only pertains to the respondent number 6 to 12, who are the performer respondents. Taking into account the above, the petitioner is directed to take fresh steps upon the respondent numbers 1 to 5 by Dusty.
No, my lord, they will not accept.
By way of registered post within 3 days from today. List the matter after completion of service.
Apply.
to item 67.
Yes, who is appearing for GMDA?
Esporal.
Huh?
In one pair. Told me that in BTS, that it may be taken at
830 days delay. You want this court to condone it and then grant you a stay today.
No, stay I have prayed under 151. There is a
151, this court has no jurisdiction.
there is a judgment of this honorable court that when there is a
Two
control-
judgments are there, but this court is not going to listen to all this. When was the judgment passed? Trial court?
trial court passed the judgment of
The first appellate court?
first appellate court for 2009.
2019.
499.
4919. Then what happened?
Then Lordship, the present petitioner, they were not the parties in this. But actually they are the aggrieved party.
They were not parties to the suit
No,
or the appeal.
no,
They were not parties to the
no, no,
appeal.
in the suit Lordship,
In the appeal.
but present petitioners were not a party.
Were they parties in the appeal?
They filed an entitled appeal Lordship,
Yes, you are party in the appeal. You are the appeal, appellant.
appellant, but
Then-
as a aggrieved party. Appellants are not the parties in the suit.
Maybe, but you were the appellant.
Yes,
We are not, we are in second appeal. So understood, you knew it very well. Your suit, your appeal
no,
was
Lordship,
dismissed
the
on.
counsel did not inform me, and even the plaintiff who filed the suit, builder, Lordship, he did not implicate me in the present petitioner in the suit, Lord. The GMDA did not issue any notice as required under section 88 of the GMDA to the occupier, that is the flat owner. Appellants are the flat owners, Lordship. They purchased the flat Lordship, and in 2004, Lordship. It took the position in 2005, Lordship. And the GMDA without notice, all notices were issued Lordship for another alleged unauthorized construction to the builder, not to the present appellant or the aggrieved party.
Why? Why should the notice be issued to you? Who has taken the
So I am
permission?
the occupier, I am.
Who is who has taken the permission?
Lordship.
Who has taken the permission?
For construction, builder has taken,
So,
but I have.
You take
purchased
up the money from the
No,
builder.
Lordship, I have purchased.
I
it.
still remember the judgment of the Supreme Court wherein says in respect to Priyanka estate, you are aggrieved, file a case against the builder. Take the money from the builder.
No, Lordship, fact of the case is this Lordship, the builder. First of all, he obtained NOC up to for the construction G+4 building.
Are they going to demolish today or tomorrow?
Tomorrow, Lord,
Okay, we'll have it after 6 months.
30 gross illegality has been committed by the
Absolutely no.
Lordship. Please, Peru.
What is your grounds of second appeal?
Second
The second
appeal-
appeal,
Mainly, Lordship, apart from other, the builder, when he has applied for the extension of the 5th floor, Lordship, that was. no-
yes, Mr. Bora. You are going to demolish it tomorrow.
I don't have that.
Then
Last year, Lordship, may please look at Peru, the last annexed Lord.
of which application?
Memo appeal, Lord.
Memo of appeal. And what is this memo of appeal has so much of annexed?
Page 192, Lord. Page 192, annexed state.
92,
Page,
92, yes.
Lordship, this is the notice dated 15 to
In
24.
inviting reference to inform you, the
Issued,
GMD is going to demolish the 5th floor of your building, Iman of the Iman in pursuance to the order of the therefore you are hereby
Lordship, this is the only notice which was given to the flat owner. Before that, 88, section 88 notice was not given.
not
Section-
necessary.
section
Section 88 notice was very much given to that person.
No, no, it should be given to the occupiers also,
No.
Lordship.
Show me
Yes,
that.
yes, yes,
Show me
very
that.
clear.
Show me that.
Section is very clear. Lordship, will please refer to where any development has been commenced or is being carried out has been completed in contravention to master plan or development scheme or without the permission, approval or sanction referred to in section 25, section 30 of the act in contravention of any conditions subjected to which such permission, approval or sanction has been granted. The authority may, in addition to any prosecution that may be instituted under the act, make an order directing directing that such a development shall be removed by demolition, filing or otherwise by the owner, occupier, manager. So I am the occupier, I am the plate owner, occupier, manager, or any person at whose instance the development has been commenced or is being carried out or has been completed within such period, not being less than 5 days and more than a statement of the return thereof has been delivered to the owner, occupier, commenced or is being carried out or has been completed as may be specified in order, and on his failure to comply with the order, the authority may remove or cause to be removed the development and the expenses of such. Such removal shall be recovered from the owner, occupier, manager, or any person. So this is the mandatory provision, Lordship, to give notice. So I am the aggrieved person, Lordship. I am the flat owner. I have purchased
necessary.
from the.
Not necessary to give you notice. And demolish. This is the fit case for demolition.
It's a non-compoundable offense.
The basic idea of filing a suit is that, no? The reason is they knew it very well. You knew it very well that that construction at the time of purchasing, you knew it very, very well that without permission you have the fifth floor was permitted.
The developer has applied for the extension of the fifth floor by depositing the fees application.
So why did you buy?
Lordship,
Why did you buy?
Lordship,
Your case is squarely covered by the judgment of the Supreme Court in Priyanka Estate. Absolutely covered.
Lordship, there are other Supreme Court.
What do you want? Should I dismiss on the ground of delay, or should I dismiss on by condoning the delay and dismiss no question of law? Right? Court is not going to entertain this type of matter. Absolutely, you have been very successful in delaying the matter before the trial court by filing a suit, then filing an appeal.
No, suit was not filed by the urgent petitioner, appellant. Suit was filed by the builder.
Understood. That is why.
I was
Very
not
well,
the
the
counsel
builder.
for the builder.
The grounds which have been given is not there.
No, Lordship, the case, Lordship, will be pleased to consider that as per the Guwahati Municipal Corporation bylaws, building bylaws up to 1998, there is a provision under section 327 and 328 of the bylaw, the Act, GMC Act, Lordship, that if a person applies for obtaining permission or extension of the floor, and if it is not disposed of within 60 days, Lordship, it will be deemed to be granted. So under that deeming provision, the builder has constructed the fifth floor, which was duly assessed by the GMC by assigning holding number to each of the appellants separately, Lord. And since then, the appellants are paying the holding taxes to the GMC. Lord, to me, please to peruse the bylaws of the 1998 of the GMC for the construction of the building.
To me?
Yes.
Where is it? Bylaws, first of all, does not say about theme permission. The theme permission says it is given out there in the GMD Act.
So I have submitted Lordship section 327 and 328
of the GMC Act.
Yes.
When you apply, whether the theme permission has been granted. To me. Yes.
Lordship, the last line of section 328. Provided that application shall be disposed of within 60 days from the date of receipt. Now, your Lordship, the builder has applied for extension of the fifth floor, Lordship. Bylaws also provide for giving.
Information,
bylaws number 4,
which one?
bylaws number 14 of the GMC building section 5 of 1998.
Kindly read section 88,
GMD
80, GMDA.
section 80. Where any development has been commenced or initiated or has been completed in contravention of the master plan or development scheme or without the permission, approval or sanction referred to in section 25 and section 30 of the Act or in contravention of any condition subjected to which such permission, approval or sanction has been granted. The authority may, in addition to any prosecution that may be instituted under the Act, make an order directing that such development shall be removed by demolition, filing or otherwise, felling or otherwise by the owner, occupier, occupier. This is important.
Occupier and manager or the person at whose instance the development have been commenced.
Yes.
So are you therefore saying it is at your instance the development has commenced?
No. Development was commenced by the builder lordship, but when lordship the plate was sold,
Then it is not required. Every time is it necessary for giving up for 100 building? No, no.
when the sections are mandatory lordship notice to
Not
occupier,
necessary.
mandatory
You
lordship.
have been given a heard enough.
Lordship may be pleased to peruse the bylaws regarding bylaws number 40. Bylaws number Lordship 40. This bylaw is a building bylaws for Guwahati Municipal Corporation 1998, which come into force effect from 31st/12/98. This was the first bylaws regarding the building construction when the GFC Corporation was constituted. Lordship. So rule Lordship may come to rule 40. Bylaws number 4.
Now first let us read section 327 of the GMC which you are referring to.
I had referred to
327.
yes.
Where is it mentioned?
328 Lordship last part of the para provided an application shall be disposed of within 60 days from the date of receipt.
Then?
So Lordship, I have submitted the revised plan for the construction of the building.
That I have seen it. Where is it? Deemed. Where's the
It is
deeming
implied
provision?
team lot.
No.
It is implied team lot.
You are holding this book?
Yes.
Show me that. Kindly come to that particular provision of the GMDA Act.
Then section 327 lot.
327 does not give. No person shall erect.
After the expiry of one, lot will be pleased to peruse the section 327 law.
Hmm.
Unless the commissioner or engineer so empowered has either by an order in writing granted permission or has failed to intimate within the prescribed period his refusal to grant such permission, or after expiry of the 1 year from the date of the said permission on such or such a longer period as the commissioner may allow. So let's say and Lordship, here I have applied, they did not convey anything that whether it is sanctioned or refused, Lordship. In the WS, they have the GMD stated that GMJ refused it. But when the evidence was given, no such refusal letter was filed or exhibited. Lordship, we please to exhibits of the GMD are given in the trial court decree, Lordship. So false abatements were made, Lord. Apart from that, Lordship, my next submission is this notice to me was issued in 2014, Lord, and this is Lordship Guwahati Building Construction Regulation Bylaws 2014, clause number 6 provides that.
And notice was issued in 2005.
Not in 2005, notices were issued to the builder, not to the
No, forget about you. You are consequent. 2005. When did you enter into a sale agreement with the builder?
In 2005, we took the position and deeds were executed.
In 2005.
Yes.
So 2005, he applied for permission on 11/10/2005, and on 11/12/2005,
No,
he
applied,
thought
he applied Lordship on 6/10/04.
he applied on when, as per the
He
plain.
applied. He submitted a revised plan for the fifth floor Lordship to the on 6/10/04.
6/10/04.
Yes.
And then on 11/12/04, he did not get it, so he made the construction
No, after expiry of executory period of 60,
of 11/12. So he raised the construction.
which was duly assessed.
So now who has taken up the action against them, against you by the GMDA? So it does not foreclose them. The commissioner may not do it, but why not the GMC?
Even if
And get me the judgment in Priyanka's
And
that
Lordship,
exactly
there
this is the issue.
Lordship, there was Lordship is aware there was a judgment dispute between the GMDA and GMC. Will issue the working permit or planning permit.
That has gone long
Lordship.
time back.
And
We do one thing. We dismiss this on 830 days delay. We dismiss without the right. But then the delay is not sufficiently explained for which we did.
Lordship wants that Priyanka state citation.
And who did not inform you? Inform the client?
Lordship builder as well as my
Advocate?
Yes.
Who was the advocate?
advocates were as per the certified copy N. Jha. You were
And
N. Jha.
A.K. Rai.
Yes.
A.K. Rai is with you?
No, not now. He has left. He is doing independent. He is my nephew, but he is doing it independently.
He
Today
did
also
nothing.
he are good again.
Sorry. We dismiss this.
Lordship, may we please to peruse the provisions of this. In one case, Lordship, Naga municipal case, your Lordship has held that a if some deviation to some extent can be regularized, but not a
No.
flaw. But here,
No,
lordship,
no. This is a case, Mr. Roy. This is not a case for this. You have taken enough time. You do one thing. Take out the money from the year. Exactly as per the Priyanka State judgment, which is fully
lordship, the fact of the Priyanka statement entirely different.
absolutely same. Because of the fact that I was a lawyer in Priyanka State, I knew
I
it
was also one of
exactly.
the lawyers.
You were not the lawyer in the High Court.
Yes,
I was the lawyer in the
That
High
is
Court.
reported judgment. My name is there.
I don't know
Yes, yes, I'll get
whether
to
it is
just
there.
now, Lord.
But the fact that that was a case where exactly the same thing happened.
No, lordship. They
There
did not
was a
take
case.
permission.
No, Mr.
They
Roy,
did
kindly
not
tell
take-
you exactly. Let me tell you. I still remember those times. He got the permission up till the 5th floor. He applied for the permission for the 6th, 7th, and 8th.
Yes.
That was not granted.
That was not granted.
Listen. Then the appellate forum granted it. You have an appeal. The appellate forum granted it. Matter went to the administrator. The administrator out there, who was the year, have also held it. No, this permission could not have been granted. Thereupon, the builder does not stop there. The builder went ahead to make the appeal 8 was there. 9, 10, 11, 12. Another 4 weeks, which was never to the notice of anyone. Then the question came up. The GMC had granted the permissions. That one also the deemed permission or whatever may be. GMDA issued notice. When GMDA issued notice, we took that point. That look here, it could not have been done because of the fact that GMC had given all these things. How could the GMDA do all this? That was rejected. Secondly, it was said that these have been properly assessed. The division bench rejected that and saying the properly assessed or not is immaterial. Assessment is only for the purpose of revenue, which have no bearing out there for any other purpose. Then directed us to demolish it within a particular, otherwise the government would take it up. After the government had taken up, we filed an application along with, now you see me, people like you, means not you, Mr. Roy, the appellant out here, the people like the appellant were also filed a separate petition. They came up and said, look here, we did not know all these things. The builder categorically showed us that this was properly done. He had applied, he has got the permission, but he did not inform us that the administrator, who is the appellate authority above the appellate authority, had rejected it. And as such, we should not be harmed. We have nothing to do. The division bench did nothing. And we stopped there. The division bench stopped it. Matter went to the Supreme Court, appeal filed by people like your appellate before the Supreme Court. The Supreme Court held nothing doing. It is required to be demolished. However, those appellants were permitted to file suits or compensation proceedings against the builder. That's it. You want that order, I can give it to you.
No, my present case is
You don't have a case.
different lot. Different lot. The lordship, in Priyanka case, further FIR not available to the builder lot. Here in the present case, lordship, the further I was entitled to construct this plot because I was entitled to have the further FIR lot. So Supreme Court in such a
Mr. Counsel, let me tell you, further FIR is a different aspect of the matter, and another thing is there is no question of compounding on the extra height or building, extra floor. There is no question of compounding.
lordship,
Forget about the FAR.
the building bylaws of the lordship.
Now tell me what you want. Should I dismiss the application for condoning? or should I dismiss everything?
Lordship, against the condemnation petition and notices may be issued.
Notice, isn't it that is it necessary for me to issue a notice if I'm not satisfied? He is there, he's opposing.
Lordship, when there is no
Opposing
affidavit in
to
when
But
there
the
is no
Priyanka
affidavit-
state, my lord, there is there.
Delay on the
but
face
delay
of it,
there.
1609 days delay.
Well, even that he himself says that in 14 he knew it, there's a notice. He didn't went for appeal under section 71 of the GMDA and went on with the other cases.
Lordship, notice was served to the appellants in 2004. Already I have 24. I have already placed before your Lordship, page 192, Lordship. Sorry, page, Lordship. Annexure
Now the notice
Annexure
has
10,
been
page
given to you.
192.
Now notice has been given to you.
It's for vacating, Lordship. For so cause or personal hearing, no notice was given. Prior to this 15 to 24, no notice was issued to the appellant, who are the occupiers or later.
Not necessary.
And Lordship,
You
if
are opposing the
Strictly, my lord. Against the law, my lord. The Priyanka state is there, Sujata Pathak is there, and other cases are there. Section
Lordship,
71 has not been
my case
exhausted.
is standing on it. My humble submit, my case is standing on a different footing, Lordship. When the Lordship have produced the living provisions, Lordship, and Lordship be pleased to produce the decree.
Huh?
Decree of the learned trial court, Lord. Just that GMDA never submitted any application addressed to the builder for refusing the sanction of the fifth floor, Lord.
So,
Decree page 1 to 9.
so what?
Lordship, in WS, they have stated that the permission was refused. They have not submitted or exhibited in the before the trial court. Just your Lordship, may please to peruse the annexure 5, Lordship, page 129.
No substantial question of law.
Lordship, may be pleased to peruse the appendix 3 of the building construction
No,
bylaws, Lordship.
all these things now, things
Wait,
we go
Lord,
to the
my
Supreme Court.
submission is this, Lordship.
Appendix 6, my lord,
All these things should go now to the
Lordship, these bylaws provide that if a building is found that though no permission was taken, but if a building is found that it has been constructed by leaving the proper front space, back space, and rear setback, Lordship. In
They are
that
referring
case,
to bylaw number 18.
pardon,
Bylaw number 18. 1A.
18 of which bylaws, which year?
CMC.
Huh?
CMC bylaw number 18. you are
Now
referring.
many bylaws have come, Lord.
I'm not
Which-
concerned. At that point of time, the 98 bylaws were holding the faith. This is a serious case where it should be dismissed. And I think the best option is you should be
Lordship,
given the liberty to fight against them, against the builders asking for.
Lordship, the Supreme Court judgment is there. Your Lordship is fully aware where an act provides to say giving provision, it court should give the fullest effect.
Where's the deeming provision?
Already I have placed
There's no deeming provision. No.
So bylaws provide.
The deeming provision is there only if you see section 25(4) of the GMDA Act, which categorically mentions that if within this period the construction permission is not done, it shall be deemed, which is not there. You don't have a deeming provision under 327 or 328.
By Lordship, the 1998 bylaws number 14 clearly provides regarding the giving provision law.
Show me that
Yes,
1998. Where does it say?
14 bylaws. This is bylaws of 98. At page
Where? Sanction with or without modification or refusal. The government, the authority may either sanction or refuse the plan and statement or may sanction them with modification or direction as it may deem necessary and thereupon shall be ready for issue. However, for proposals which are required to be scrutinized by committee for approval, the same will be required for issue within 90 days. The sanction once accorded shall remain valid up there. Then where is the deeming provision?
Lordship, when the statute provides that the permission will be issued within a period of 60 days.
That
And if it is
no.
considered by the
No. You have that book now. Kindly see section 25 of the GMBA. (25)(4), where you have a similar provision like this. The authority shall not refuse the permission except on the ground of contravention of the proposals contained in the plan or the zoning regulation, and unless the permission has been refused within a period of 1 month from the date of the application, or such other information as may be called for by the authority under subsection 3, it shall be presumed that the permission has been given. This is called a deeming provision.
the deeming provision, Lordship, but Lordship will be pleased to.
We do one thing. We dismiss your application for condonation, touching again on the merits. And they were giving you the liberty to move in terms of your authority. That is the best.
There is a Supreme Court.
When, how much time will you take to vacate?
If they are the lower middle class.
There is no lower middle class question. Lower middle class, higher middle class, these are classes that have nothing to do. You have purchased a house in the 5th floor of a beautiful building out there, knowing fully well that there was no permission.
Then Lordship,
So better
give
off,
me some
I
time
think
to
you-
obtain inspection.
Huh?
Give me some time.
Leave it at
No,
2.
Lordship, I will not.
2, call up your people and find out how much. Because then I will extend the period till death. Give
So
you
that-
another year so that
the
I
appellate-
only order.
So
These
that
are all, at the end of the day, this is a 2005 or 7 proceeding for demolition. It is still continuing. An illegal construction is going on. It can't happen like that. And one has to be very strict. The first of all, why on earth did the Munsif at that point of time grant an injunction?
Lordship,
Shouldn't
the
have
suit
granted an
was-
injunction out there.
Lordship, may be
Taking into account the judgment of Chief Shankar Sadda, 1993, 360 page. He could not have granted that injunction. What is this type of
Lordship,
injunction
even
against
the-
illegal construction?
Lordship, the suit which was filed by the builder was barred under section 95 of the GMD Act, Lordship.
Absolutely.
Yeah, absolutely. But the learned trial court tried it. So the Lordship, the defendants had taken the plea. So that is a nullity in the eye of law. The learned trial court, why the learned trial court in the judgment
If it
had
is a
Lord-
nullity, then all the
Oh,
more.
no,
I will take. Okay, I will take that also as
Ah.
a.
Lordship
for
is pleased to
dismissing a-
consider that learned trial court held that a aggrieved party has no right, late honor, to file challenge. That is the finding given by the learned trial court. Whereas it is well settled law that aggrieved party can file appeal. There is no bar.
The best way it was done at that point of time is looking out here in Priyanka's case, this thing has happened. Why not better try our luck out there before the trial? Because at that point of time, if I remember, all building demolition matters were taken up by the division bench.
Yes.
So better off, why not move the civil court and get an injunction?
They have also bypassed the section 17 or 71. Appeal also they have.
Oh, Lordship. Trial court
Okay,
must be
2 o'clock, you get your instruction. How much time?
I don't think they will agree to make it.
No, I'm only giving them a concession of 2 months. Otherwise, it is going. The hammer is going to fall upon you tomorrow. That is what I'm going to dismiss it. There is no quarrel with that. I'm dismissing it right now. But the only question out here, I'm asking you, how more time do you want to vacate? If you don't want, okay, then go to. Yes, Mr. Yeah, man. Why don't you try your luck with the GMT or GMD of court? That is better. Because if I dismiss it here,
Your lordship.
better off.
Here, your lordship, in a demolition matter, if demolition order cannot be passed without giving personal. This is a Supreme Court decision, lordship, 2006, 880, page 590. In the present case, lordship, the present appellate were not given even any opportunity to show cause. No personal hearing was taken, lord. That judgment. Para 29. Okay. Para 29.
Yeah, the notice was duly given to the owner.
Even to the owner's lordship, I am
Oh,
the agreed
You are,
party,
you are no
lordship.
business. You are claiming right. Tomorrow you may say, oh, my son was not given. I was only given.
Lordship, the section 88 itself provides for giving.
Occupy, is it your son also a occupy?
And the other petition I rely, lordship, is, uh, two thousand 23 3 STT 195 lot. No, sorry. Okay. Only this. It will not like. So in the present case, lordship, no support to the plate owner, no personal aid, total violation of the
So better off try your luck with the GMDA. If I dismiss it here, your matter is finished. You are given the time, file a representation.
Then, lordship, I may be allowed to told I will file appeal before the district. That's for the
Under what?
CMDA.
Not appeal. No appeal business. There's no appeal business here. When the matter has already been decided, there's no stay up.
Lordship, but on a conjoint reading of the section 327, 328 and bylaws number 14, it is clear,
It
lordship.
therefore, the question therefore was, can the GMC commissioner demolish? No. The answer is no.
Lordship, after your lordship will recollect, when there was a dispute between the GM and GMC, the High Power Committee was constituted by the Water Development Committee, lordship, and thereafter a circular was issued that henceforth only working permit will be issued by the GMC and power of demolition will be vested with GMC only. Nowadays, GMD never does any eviction, lordship, or demolition of the unauthorized construction, and that plea I have taken in my memo.
Take those pleas out there which does not fall within the ambit of your suit.
No, now in lordship, the GMD does not have any power to demolish anybody. That I have quoted, your lord. the entire proceeding was started, Lordship, on a complaint lodged by the respondent number against the builder. And your Lordship is aware that apex court has, in a judgment, has held that after builder completed the construction, Lordship, and when the sale deeds are executed, the builder ceased to have any interest in the property. The builder has nothing to do after selling it.
Tomorrow, if you sell it, tomorrow, if you sell your building
I cannot sell building.
and an order is passed against you, I'm asking you, an order is passed against you. The person who succeeds the building has also would be bound by that order which is being passed against you. So these are fundamental questions. Hello.
Lordship, when no proposed notice was issued, Lordship, no personal hearing was given, and the Supreme Court has held that no building can be demolished without giving personal hearing. That is sufficient, Lord.
No.
Lordship may be apart from that, Lordship may be pleased to come to my memo appeal page 47, Lord. The permission, the provision, Lordship, the provisions of the Lordship, the GMD Act have been repealed, Lord. Some of the regarding construction. Lordship, I have quoted that repeal and saving 47, page 47 of the Section 17, Lordship of the relevant provisions of the Guwahati Metropolitan Development Authority Act 1985 and the Guwahati Municipal Corporation Act 90, along with all amendments up to date, inconsistent with this act, shall be repealed with effect from the date from which this act came into force. As such, the relevant provisions of Assam Town and Country Planning Act 1959, Assam Municipal Act 1956, and the Assam Apartment Construction and Transfer of Ownership Act, along with amendment, update, and the regulation framed thereunder inconsistent with the provisions of the Act of 2010, and that is the Guwahati Building Construction Act, cease to operate within the Guwahati metro area. So how the GMD can, Lordship, exercise the power, the provisions with powers were given to the under the provisions of the Act of 2010.
Mr. Roy, did you withdraw the wakalatnama from in title appeal number 113 of 2013? So you were the counsel.
Earlier I was maybe counted.
Then you did not withdraw the wakalatnama, and now you are saying that the same lawyer, you are the person who had
No, I
certified.
had left that case.
You have certified the appeal.
No, not
Certified that the above grounds are good. SP Roy. Then okay, we dismiss this right away. Now I'll impose cost for you. Exemplary cost for misleading the court. This is an application under section 5, application under order 41 rule 3A of the Code of Civil Procedure 1908, for short the code, read with section 151 of the said code, as well as section 5 of the Limitation Act, for condoning the delay of 830 days in preferring the accompanying second appeal against the judgment and decree dated 4/9/2019 passed in title appeal number 113/2013 by the learned civil judge, senior division number 3, Kamrup Metro at Guwahati. From a perusal of the said application, it reveals it has been categorically mentioned in paragraph number 4 that the petitioner oblique the appellant had engaged Sri N. Jha and his juniors as their advocates for preparing and conducting the said title appeal number 113/2013, and neither the said learned counsel for the petitioner oblique the appellants nor the builder the respondent number 5 informed the petitioner oblique appellants about the dismissal of title appeal number 113/2013, and as such the petitioner oblique appellants had no knowledge and information regarding the dismissal of title appeal number 113/2013. It was further mentioned that it was only on 15/2/2024 the petitioner oblique the appellant came to know about the dismissal of the said appeal when they received a letter from the Chief Executive Officer, GMDA, stating that the GMDA is going to demolish the 5th floor of the building, Golden Residency, in pursuance to the order dated 4/9/2019 passed in the said appeal, and the petitioner oblique appellants were directed to vacate their flats within 21 days from the date of receipt of the said letter. Thereupon, it is the further case of the appellant that they had the applicant that they had thereupon obtained a certified copy of the judgment and decree dated 4/9/2019 passed in title appeal number 113/2013 on 17/2/2024, and the same was supplied on 22/2/2024. It was therefore stated that in view of the order passed by the Supreme Court in miscellaneous application number 21/2022, arising out of sumoto civil writ petition, civil number sumoto civil writ petition civil number 3/2020, the period from 23/3/2020 till 28/2/2022 has to be excluded while computing the period of limitation. Further to that, in paragraph number 8, it was mentioned that after obtaining the required certified copy and the documents, the petitioner, the applicant oblique appellants, engaged Sri S.P. Roy, advocate, on 24/2/2024, and the learned counsel thereafter drafted the memo of appeal, stay petition, and the condonation petition from 25/2/2024 and finished on 1/3/2024. And as such, there was a delay of 1,640 days in filing the connected appeal from 4/9/2019. But after excluding 90 days of limitation, as well as the period of 715 days, in terms with the order passed by the Supreme Court in miscellaneous application number 21/2022, the actual delay is 830 days. This court have duly heard Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner. The Mr. S. Pura appears on behalf of the respondent GMDA and submitted that on the face of it, submitted that the said application on the face of it contains incorrect details. Full stop. And as such, the delay which has been explained cannot be, ought not to be condoned. Further to that, the learned counsel appearing on behalf of the appellant, respondent GMDA submits that the issue involved in the instant proceedings stands squarely settled by the judgment of this division bench of this court in Priyanka Estate International Private Limited and others versus State of Assam and others, reported in 2007 1 GLR page 473, 1 GLR 473, as well as the judgment and order of the Supreme Court, whereby the said judgment of the Supreme Court, the judgment of the learned division bench in the case of Priyanka Estates International Limited, Supra, was affirmed. That is, in the case of Priyanka Estate International Private Limited and others versus the State of Assam, reported in 2010 2 SCC 27. Therefore, it is the submission of the learned counsel appearing on behalf of the respondent GMDA that the question that even on merits, the appeal has no legs to stand. This court have, while hearing the application under Section 5 for condonation of the delay, had also the occasion of perusing the contents of the memo of appeal. And it shocks and surprises this court in the manner in which the applicant, the appellant, have made false statements in the said application, in as much as it has been mentioned that the learned counsel, that it was mentioned in paragraph number 3 of the said paragraph number 4 of the said application that Sri N. and Jha and his juniors were only engaged for preparing and conducting the title appeal number 113/2013. And these counsels did not inform about the dismissal of the said appeal on 4/9/2019, whereas a perusal of the memo of appeal encloses Annexure 6 to the RSA, to the memo, a perusal of the memo of appeal in title appeal number 113/2013 encloses Annexure 6 to the memo of appeal of the second appeal, clearly shows that the said memo of appeal was certified by Mr. S.P. Roy, the learned counsel, who is now being represented, who now represents the appellants, the appellants. Full stop. The above stand, therefore, on the face of it appears, the above stand taken in the application for condonation of delay on the face of it, therefore, appears to be a false stand taken in order to, by blaming the counsels whose name appears in the decree of the first appellate court. Further to that, it is completely unbelievable that the appellants, the applicants who were parties to the title appeal number 113/2013 and was not aware of the said proceedings, or for the purpose, the dismissal of the order dated dismissal of the said appeal by judgment and order dated 4/9/2019. The grounds on the face of it do not constitute a sufficient cause within the meaning of Section 5 of the Limitation Act, for which this court has no reason to condone the delay of 830 days in preparing the instant appeal. This court further finds it relevant to take note of, observe that while considering the application for condonation of delay, now this court also finds it very pertinent to take note of that at the time of taking up the application for condonation of delay, the learned counsel appearing on behalf of the appellant submitted that the proceedings, that the demolition proceedings should be stayed pending disposal of the condonation application and admission of the second appeal on substantial question of law. Under such circumstances, this court have also had the occasion of going through the merits of the appeal as to whether any such order could be passed. This court finds it very relevant at this stage to take note of that the permission which was given to the builder, that is one Shyam Sundar Stipani, who was the original plaintiff, was for ground to fourth floor by permission dated 6/10/2004. Within 4 days thereafter, on 11/10/2004, within 2 days thereafter, that is on 8/10/2004, an application was filed for extension of the fifth floor, which was submitted before the GMC authority on 11/10/2004. The said application was not The same application which was for grant of permission for the 5th floor admittedly was not accorded. However, it has been the case of the plaintiff that there is a case of a deemed permission if the permission was not granted within a period of 2 months from the date, within a period of 60 days from the date of submission of the application. The entire edifice of the said case of the plaintiff was on the basis of a reading of section 327 and 328 of the Guwahati Municipal Corporation Act 1971. This court have duly perused the said provisions, and from a perusal of the said provision, there is no mention whatsoever that not granting an extension, not granting a permission within a period of 2 months from the date of the application can be construed to be a deemed permission for construction. In fact, under such circumstances, the construction which was made for the 5th floor was on the face of it illegal and unsanctioned. Be that as it may, the builder who was the plaintiff had sold off the flats on the 5th floor to the appellants herein. And the in such circumstances, this court finds it very relevant to take note of the judgment of the division bench of this court in the case of Priyanka Estate International Private Limited. The judgment of the learned division bench of this court in the case of Priyanka Estate International Private Limited, Supra, wherein the learned division bench of this court had dealt with the provisions of section 327 and 328 of the GMC Act of 1971, and also the provisions of section 88 of the GMDA Act, the Guwahati Metropolitan Development Act, as well as the provisions of section 87 and 88 of the Guwahati Metropolitan Development Act 1985. In the said judgment, more particularly at paragraph number 47, it was opined that section 327 of the Act of 1971 stipulates that no person can erect or re-erect without the written permission from the authority. Section 328 of the Act of 1971 provides for issuance of a notice by the person who intends to erect or re-erect the building enclosing therewith the ground plan, elevation, and section of the building, as well as the specification of the work. The court, the learned division bench, had also taken note of bylaw number 5 of the building bylaws, which also requires that such notice under section 328 shall be accompanied by the site plan and the building plan, and conforming to the requirements of section 327 and 328 of the Act of 1971, in triplicate on blue or white print, and a copy of the plan is to be retained by the authority after issue of permission, and other 2 copies to be retained by the applicant. It was therefore opined that what is to be approved is the site plan as well as the building plan submitted by the applicant for construction. Unless such building plan is approved, no construction can be made by the person, even if an appellate authority passes any order to the effect that the applicant be granted permission as sought for. In that case, it is very relevant to take note of that the standing appellate authority had granted the permission But the learned division bench of this court categorically held that the order passed by the standing appellate authority was void ab initio. Under such circumstances, this court also finds it very relevant to deal with another submission of Mr. S.P. Roy, the learned counsel appearing on behalf of the appellant, wherein he submitted that irrespective of issuance of notice to the builder, each occupier has to be issued a notice. This aspect of the matter has also been taken care of by the learned division bench in his judgment in the case of Priyanka Estate International Private Limited, Supra, wherein in paragraph number 52, it was categorically observed that the requirement of issuance of notice under section 88 of the Act of 1985 cannot be stretched to such an extent that when the building has been constructed by the builder, even after issuance of a stop construction notice and during the pendency of the writ petition challenging such notice, the occupier of such building to whom it is sold is required to be issued with a notice before passing an order under section 88 of the Act of 1985. Full stop. It was further observed that once that paragraph number 52 of the said judgment being relevant is reproduced hereunder. This court further finds it relevant to take note of the judgment of the Supreme Court in the case of Priyanka Estate International Private Limited, which have been Supra, wherein the Supreme Court, while affirming the judgment of the learned division bench, had also observed at paragraph number 55, paragraph number 50, that if the constructions are in absolute violation of the sanctioned or approved plan and are not likely to fall in the category of compoundable items, then the necessary consequence is to order its demolition, and seal of approval for such illegal activities is not required to be given by this court. In paragraph number 55 of the said judgment, the Supreme Court further observed that illegal and unauthorized constructions beyond the sanctioned plan are on a rise and may be due to paucity of land in big cities. Such activities are required to be dealt with the firm hand, otherwise builders or colonizers would continue to build or construct beyond the sanctioned plan, sanctioned and approved plan, and would still go scot-free. Ultimately, it is the flat owners who fall prey to such activities, as the ultimate desire of a common man is to have a shelter of his own. The Supreme Court further observed that such unlawful constructions are definitely against public interest and hazardous to the safety of the occupiers and residents of a multi-storied building. To some extent, both the parties can be held to be equally responsible for this. Still, the greater loss would be those of the flat owners whose flats are to be demolished as compared to the builder. Under such circumstances, the Supreme Court, in the said judgment, while exercising the power under 142, Yeah. However, the in the same case, the Supreme Court, however, did not exercise the power under 142 of the Constitution, but gave liberty to those flat owners whose flats were ultimately going to be demolished to exhaust the remedy as available to them in accordance with law against the builder. Paragraph number 50, 55, 50, 55 to 62 being relevant is reproduced hereunder. The above materials, above aspects would also clearly show that the substantial question of law which were urged were also show that there is no merit in the appeal as no substantial question of law arises. Because under such circumstances, this court, even taking into account the plight of the appellants herein, is not under such circumstances, this court, taking into account the above facts, which categorically show that the petitioners here, the appellants herein, were clearly negligent, for which the delay cannot be condoned, and even on merits also, they did not have a case. So consequently, the instant application for condonation of delay stands dismissed. This court further, taking into account that the application contains false statements, contains statements which on the face of it are made, contains statements which on the face of it appears to be false, is of the opinion that exemplary costs should be imposed upon the appellants, for which this court imposes a cost of rupees 50,000 to be paid by the appellant.
Documentary item 63, fixed at 2 p.m.
Yes, what is this? 584 days.
Pilot may first pick up 3207.
What is this?
Here the ground pilot I have categorically stated in paragraph 3 and 4.
Yes.
Here, my lord, initially the applicant has plaintiff instituted the defendant, plaintiff, the present applicant has plaintiff has instituted. The defendant filed their counterclaim was the suit. So, as a matter of procedure, two separate appeal would have been. But because of one of the mistake on the part of my counsel, only one appeal, a single appeal. The appeal admitted for hearing.
That appeal has been admitted for hearing within time.
That was during pendency of that appeal, my lord. My counsel has discovered the mistake, that it was because of mistake. In fact, separate appeal ought to have been. Another appeal with the condonation of litigation. The subsequent appeal which was filed against this decree of counter. So during pendency, that appeal was initially not ordered because it was with the application for continuation of delay. So the hearing on application of continuation of delay was pending. During this time, the first appeal period, it was dismissed on the ground that it was, since the value of the suit was only 900, and section 96 says for the municipal code, it less than 1000, only on the, if the value of the suit is less than 10,000, then appeal will lie only purely on the question of, and the appeal was preferred both question of law and, so it was dismissed without going on debate on that. That time also, my lord, we have not come, because during that period, the subsequent appeal which was preferred, it was pending for hearing. So we have been advised that wait until the final order. Where subsequently the appeal was dismissed on the ground that delay was not done, and it was. So accordingly, we filed after dismissal of the subsequent appeal.
Now against which appeal we have, you are,
In first, we have 584-day delay.
how many matters are?
63 and 60.
Huh?
Item 63 and 62.
64.
64. 64 IA is
How much is that delay?
375. So this is the, there are two parts. On the other day when the matter came up for, your lucky was taken up the matter. The first part is that this is the bona fide mistake on the part of my company. It was not, my lord.
No, the habit of giving putting bona fide mistake upon the lawyer cannot be the ground. You can't take every time we see
After
only that.
dismissal of the subsequent appeal, my lord, there was some delay because, my lord, in the meantime, my lord, my counsel who conducted my case, he expired. So these are the basically
Was there only one lawyer?
who conducted my,
No. Was there any one lawyer?
he was the main.
No, there's no main business. Then stop filing wakalatnama of so many people. You can't say that.
So this is the reason.
No, everybody has to be responsible. You can't. This is not the manner in which you can go on like this.
So
No?
this is my.
I think we are in the 21st century, and in the 21st century is this.
Here only my humble submission is there. As your people, my lord, well aware of all things. The basic thing is the, my lord, whether the explanation is, my lord, sufficient. This is to be considered. So my humble submission, my lord, the first part that because of the ignorance of procedure, that
There cannot be an ignorance of.
my counsel has mistaken.
Oh,
This is
that
a
is
one
your
mistake on his part.
that is why it is high time these lawyers to be brought within the consumer.
Client, my lord, client has no, my lord, forum to judge their advocate. So this is also, my lord, that if you go to two pages, my lord, I have with me, my lord, I will take that maybe if it appears that the mistake is bona fide, then it may be a ground for continuance. So my humble submission, it is a bona fide mistake, my lord, because the procedure, my lord, he simply because it was a common judgment. Against a common judgment, he preferred only single appeal. This is my humble submission, bona fide mistake. Then the sudden death, my lord, after it is always, my lord, the custodian of the file is the, my lord, leading counsel, who is the arguing counsel. Associate counsel normally the doctrine knows do not take file.
Huh?
We have to break the file, my lord. So this part, my lord, kindly be considered because appeal, my lord, my.
Yes,
humble
Mr.
submission is-
Mahmood, you file objection.
It is,
What is your objection?
may
Yes, yes, tell me. The moment I'm asking that I am sympathetic, that is why. Ah.
Now, they have filed I have it
Hmm.
down for the first.
Hmm. Mr. Counsel, whether it was not fixed, whether it was not fixed in the cause list, that a judgment would be delivered? 100%.
judgment delivered, that it is, we have the knowledge.
Yeah.
That is the first appeal. When the first appeal was, my lord, preferred, dismissed, at that time the subsequent appeal, that is preferred against the decree of, my lord, decree in counterclaim, that was pending.
Hmm.
So we have been advised that it is better to wait until the outcome of the subsequent appeal.
Hmm.
Therefore, it is not a case, we have not pleaded that we have no knowledge.
Hmm.
It is a case, my lord, that we have the knowledge, but because of some
Then why you are saying
technology
that,
mistake on the part
why
of-
you are saying that you don't have knowledge?
that part, that
You have categorically stated you had no knowledge.
That
Only
is the
after the death
this-
you have come to know in the month of September
this is, my
2023.
lord, subsequent appeal, regarding subsequent appeal.
We are concerned with 9/5/2022. Why did you say that you have no knowledge then?
9/5/22, yes. 9/5/22, this is subsequent appeal. Therefore, because of my counsel, the arguing counsel, after, my lord, conducting the argument.
I am asking you, was there only one lawyer in the who had signed the Wakalatama?
my lord,
It will be apparent from the decree. Take these things back. But yeah, no, I think we, as a High Court, can't be lenient of it. Condonation, if it is a case of substitution, one can be free. But not in this manner.
Appellate judgment.
When did your counsel die?
I have made statement. 3209. IA 3209.
3209.
09 IA.
What is 3209?
IA number 3.
I'm not concerned. You don't know the dates?
Yes, my lord, I have given the
When?
24 to 20.
24 to 22, you have died. On the he appeared on hearing on 17/12/2019. On 23/12/2019, the judgment was delivered. Then you didn't have the audacity to ask him. Thereafter, he died only on 24/2/2022.
In the meantime, my second subsequent appeal that was pending.
I am concerned with this. So
Therefore,
this needs to be
this
dismissed.
appeal was pending.
This first,
Therefore, this is the reason that two appeal, first one. during
Mr. Counsel, let us go one by then.
Yeah.
Second, we'll go. First, let us dismiss 3207. Look,
I am relevant to judgment.
rely all these before the Supreme Court. Yes. This is an application for condonation of delay of 5. This is an application under Section 5 of the Limitation Act for condoning the delay of 584 days in filing the connected regular second appeal against the judgment, appeal against the judgment and decree dated 23/12/2019, passed in title appeal number 42/2017. Full stop. This court have duly perused the said application. And from the said application, more particularly at paragraph number 5, it reveals that the counsel who was appearing on behalf of the appellants had died on 24/2/2022. That is prior to the dismissal of TA number 30/2019. And as such, the applicants were not aware of the date of their counsel, nor had the about the dismissal of the title appeal number 30/2019 on 9/5/2022. It was mentioned that they came to learn about the date. They came to learn about the date of the engaged counsel in the month of September 2023. And thereupon applied for the certified copy of the judgment and decree dated 9/5/2022, passed in title appeal number 30/2019. And when did you file against the judgment and decree dated 23/12/2019 in title appeal number 42/2017? When did you file?
Appeal. That appeal before the first appeal, that was in time. Appeal number 42.
No, here.
Here, my lord, same day, both the
How? Why this was there? Because this judgment was delivered in the year 2019.
90.
Then?
Because, my lord, in the meantime, that I have stated, my lord, your lordship kindly peruse paragraph 3 of my.
No, you filed. Here the judgment was delivered on
23/12/19. Paragraph 2 I have stated.
counsel. You made all the mess up of everything. Here, kindly come to page 5 of IA 3209 of 2053. Page 5. Okay?
Yes.
That the impugn order in title appeal number 42/2017 was passed on 9/5/2022. Whereas,
There-
here in the other petition you are saying title appeal number 42/2017 appeal was passed, decree was passed on 23/12/2019. Which is correct?
In paragraph 2, my lord, that the title appeal number 30, there is some typographical mistake. My lord is taking up the first item. Your lordship kindly say first item 63 IA is
Mr. Counsel, let us not go by this first item, second item business. Let us first know when did you file what? Tell me. Title appeal. First tell me, title appeal number
42
42
Yeah.
public 2017,
was dismissed on 23/12/19.
23/12/19. Okay. When
And-
did you file the appeal here?
Appeal here, my lord, 6/10/23.
6 or 16/10?
16/10. 16/10/23.
It was filed on 17/10. Filed on 16/10.
16/10/23.
So therefore the delay is how much?
Original delay is 1262. Paragraph 2 I have mentioned.
This is 584 days delay.
Here, original delay is 1262.
584 days delay. So you are confusing in both. Here is making this, here you making it there. This is 584
84
days delay. Total delay actually was
1262.
1262 days. Now come to title appeal number 30,
30.
public
19.
19. Now here
9/5/22. It was dismissed.
9/5/2022.
Dismissed.
Dismissed.
Prepared on
Appeal prepared on
16/10. Same.
16/10/2023.
Yeah, delay
Delay is
375.
375 days. Okay. And this, in this case only, earlier case title appeal 42/2017, knowledge of your husband,
This is not
that person not knowing does not have any relevance because he was very much there. So under such circumstances, there is no
that
ground.
we have been advised.
No,
wait
forget about the
until the
advice.
outcome of
There
the-
cannot be advice against illegal things. So this is the second is the other one. This person died on 24
to 20.
24 to
20.
22. Let me just one.
Hey, category is after.
Let me
No,
see
after
the
my-
other appeal. This is in title appeal 30.
30.
Where is the judgment and decree in title appeal 30?
30. That is copy of your memorandum of appeal,
Where is the judgment and decree?
page 60, page 60 of memo of appeal.
Hmm?
Judgment under appeal is, it starts from page 25. 20,000.
Oh, do you know, interestingly, a very interesting thing. On the date on which title appeal 42/2017 was filed, the judgment was delivered, on the very date, you filed an affidavit in Miss Case number 153/2019 in title appeal number 30 with the lawyer itself. So you knew very well that that judgment was delivered.
Yes, as regards 42, knowledge is not a question, my lord.
Now let us next.
As regards 30, knowledge is a question.
Let us see 30. Where is the judgment?
30.
9-5. 9-5. Huh? Both counsels are present. Did you appear by yourself or through your counsel on 9-5? Because your counsel died on 24/2. Yes.
No, I am told that argument was hard before.
Couldn't have been. It couldn't have been an argument would have been heard.
That query I have made, but they said after argument conducted it, concluded it.
Then in that case, the record will show.
Page 57.
No, understood. Page 60. Page 57 is what?
57 is the order, man. Miss case number 153 of 19.
Written objection filed when? On 5/12/2020.
Yes.
Then
Order is mistake in page 153. 9.
both parties are represented by the learned counsel. So you are very much present. Some other counsel was there,
Yes.
whereas your earlier counsel died.
Earlier counsel.
Then your entire
You are the
edifice, Mr. Counsel, your entire edifice is on Abdul Hakim. Abdul Hakim died on 24/2/2022. So who?
He
The
was the
ghost?
leading counsel.
Now did the ghost appear? Okay. First take on. 3209 is in respect of condonation of delay of demand in which appeal
375.
against what in judgment you don't write. That is the problem. Now you are saying about 375 days. 3209 is in respect to which second appeal? You don't maintain a single word against which appeal you are filing.
Second appeal, serial number 13037.
Because of this trouble you are giving, I think it's high time we export the
64.
13037. This is 3209. Now let me first take up 42.
That is 13042.
Mr. Counsel has made me more confused. The instant application, it is over there, 3207/2022. This is an application under Section 5 of the Limitation Act for condoning a delay of 584 days in preferring the accompanying second appeal against the judgment and decree dated 23/12/2019 entitled Appeal number 42/2017. The only reason given in the said application as was that a connected appeal was pending, for which the appeal was not filed before this court. This court finds it relevant. Take note of. That the appellant duly knew that the appeal was dismissed on 23/12/2019. Thereupon, a perusal of the condonation application reveals that on 9/5/2022, the accompanying appeal was also dismissed. Under such circumstances, the ground on which the cause which have been shown for not filing the accompanying appeal till 16/10/2023 cannot be said to be sufficient, for which the instant application under Section 5 stands dismissed. I stands dismissed. IA number 3209/2020. This is an application for condoning the delay of 426 days in preparing the appeal against the judgment, against the order dated 9/5/2022 passed in Ms. case number 153/2019, arising out of title appeal number 30/2019. It has been mentioned that the applicants did not know about the order dated 9/5/2022 on the ground that their lawyer Abdul Hakim had expired on 24/2/2022. However, a perusal of the order dated 9/5/2022, which have been impugned in the instant proceeding, categorically reveals that both parties were represented on that date, meaning thereby that the appellant very well knew, either had appeared on in person or through their lawyer. Therefore, the death of their earlier lawyer Abdul Hakim on 24/2/2022 cannot be a reason for condoning the delay of 426 days in preferring the accompanying appeal, for which this court, having not found any sufficient cause, dismisses rejects the instant applications. I
correct some practical mistake order that I have found the sending out of PWD.
PWD.
I have here.
We'll see. When Mr. Nayak comes, I'll take it.
I call it.
May I have the
Yes.
Lordship, the order, Lordship.
Hmm.
The different page is page 12. Paragraph 5.
Yes.
Lordship, according to the state petition says with the following observations direct. The one existing record with respect to second arrest Sita at Jawanpati of Multan transfer, which was seized on from the residence of Mr. Kazi, Abdul Hakim Patwari, Sita be retained. Two, my lord, the respondent authorities should be at liberty to carry out the reconstruction of the second arrest Sita at Jawanpati of transfer, seized on from the residence of Kazi Abdul Hakim Patwari as per the provisions. But while doing so, the existing record will be destroyed. So,
Be
you
not
want-
destroyed.
Lordship, the word destroyed.
The instant application has been filed taking correction of the order dated 7/2/2024 passed in WPC number 3026/2019, wherein an inadvertent clerical mistake had arisen in not mentioning the word not to in the directions passed in paragraph 5 Roman 2. In terms with the paragraph Roman 2, the paragraph Roman 2 of the order dated 5/2/2024 reads as under. Itu didi ko, ha? Read the puस्तक. Taking into account the inadvertent mistake, the said paragraph Roman 2 shall be read as Roman 2 as per the provisions of law, but while doing so, the existing records should not be destroyed. Should not. The instant order shall be a part of the order dated 7/2/2024 passed in WPC number 3026/2019. With the above the instant interlocutory applications. Yes, Mr. Counsel, give your names, huh? Yes, Mr. Malakar. When is the next date? Your item number 4?
What type me?
When is the next date fixed? Appeal.
13/5. Your Lordship, next date is fixed 13/5/2020
For
hearing.
for hearing. You do one thing. Where do the respondents stay?
Respondent is staying at the hearing. Dhupguri village. Under Poco.
Issue notice making it returnable on can you also affect the service by Dusty by 27th?
Yes.
Okay. Issue notice making it returnable by 27/3/2024. Steps upon the respondent number 1 to 4 be taken by way of registered post. The petitioner is also directed to take steps by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. This court had duly perused the impugn order dated 13/12/2023, whereby the learned First Appellate Court rejected the application under Order 41, Rule 25 of the Code of Civil Procedure 1908, even before hearing the main appeal. In the opinion of this court, the said application ought to have been taken up for disposal along with the application, along with the title appeal for hearing. However, as the said application under Order 41, Rule 25 was dismissed, rejected prior to the hearing of the appeal, which, as per the learned counsel appearing on behalf of the appellant, submits that the next date is fixed on 13/5/2024. The said order on prima facie appears to be not in accordance with law. Accordingly, the order dated 13/2/2023, accordingly, further proceedings in title appeal number, title appeal, or is it in Miss case?
Four.
Huh?
Title appeal number 4.
Four,
This case, your lordship.
title appeal number 4/2018, pending before the court of the civil judge,
Civil judge,
Kamrup at Amingaon, remains stayed till the next date.
Must
You take
be
service.
65. Yes.
Mr. Nayak, they have, what the problem happened is because of they not filing the memo parties, this problem has happened. In the original petition, by hand they corrected it as executive engineer. But what had happened, this was not uploaded in the in the CI. And accordingly, the order came as executive. So we say that this response number 5 be read as executive engineer. That's it. What happened? They corrected it. If you see in the original file, they have corrected it. That is the reason why I always ask, amended memo parties has to be filed, which was not filed. That was the big problem which was happening in, and this is going to repeat. You will be having many more issues later on if these are being not done. Luckily, it was Chief Justice Mehta who have duly corrected it by issuing that notification. Because in the CIS, it remains as it is. And they don't correct it by hand if we do it. The instant application has been filed. Seeking correction of the order dated the judgment and order dated 24/11/2023 in WPC number 5305/2022. What are the corrections you are asking?
Number 1, designation of
Designation is okay.
designation of the respondent to the professional and special secretary. Special word is missing. And
Here is the executive engineer.
executive engineer.
And then
One order about the date is that's the wrong date type of thing. That's the 21/8.
Where?
20. But date is reflected the paragraph 3 of the judgment. Page 13. Third line from bottom. 21,
The
8,
third RA bill on 21/8/2020,
20.
whereby the petitioner has sought for correction of the names in the cause title of the respondent, as well as an inadvertent mistake committed in paragraph number 3 of the said judgment, wherein the third RA bill was mentioned as 21/8/2006, which ought to have been 21/8/2020. Why should I put the special secretary in the writ petition? There is no special secretary. No, there is only executive engineer. It is not there.
Number 2 is.
Huh?
Respondent number 2.
Respondent number 2 has been shown as commissioner and secretary to the government of Assam.
Special secretary.
I can't help you. That I can't do. This court have duly taken note of the writ petition, wherein the respondent number 2 has been shown as the commissioner and secretary to the government of Assam, Public Works Department, Roads, Dispur, Guwahati 781006. And the same is duly reflected in the name of the parties in the judgment and order dated 24/11/2023. And accordingly, there is no need for, therefore, for correction of the same. As regards the respondent number 5, it is seen from the records of WPC number 5305/2022. That by hand, the executive officer has been made as executive engineer. The record, however, does not reveal that any leave was taken from this court for correction of the said name. And under such circumstances, be that as it may, the learned counsel appearing on behalf of the petitioner submits that the said correction was made after filing of the writ petition, but before the matter came before this court. Taking into account that in the Public Works Department road, there is no officer with the rank of executive officer. However, the officer ought to have been executive engineer. This court, for the end of justice, permits the correction of the memo of parties, permits the correction of the name of the respondent number 5 from the executive officer, inverted comma, to the executive engineer. The petitioner is further directed to file a fresh amended memo of parties before the registry of this court, and on the basis of which the registry of this court shall upload the same in the CIS and thereupon issue a fresh certified copy on payment of the requisite fees. Number next. As regards the correction sought for in paragraph 3, wherein there is a mention of the third RA bill on 21/8/2006 in the judgment and order dated 23/11/2023. All because of you. You have mentioned it 21/8/2006.
In paragraph, Lordship,
Paragraph 10 of your writ petition.
paragraph 22, it was
Forget about the paragraph. You
Paragraph-
have mentioned at 21/8/2006.
yes, paragraph 10, it was wrongly mentioned, but in paragraph 22. it was
This is a
correctly
cost on you. The cost.
Hello.
20,000 is cost.
mentioned. Your Lordship.
No. This I'm not going to do it. But you, what do you think? None of this. It was a mistake of the court.
I approach that.
So-
So it's a paragraph, Lordship.
No. Paragraph number 10. Read paragraph number 10 of the writ petition.
That is wrong, Lord.
Then-
I did. 22, I was correctly mentioned.
So, did you mention while hearing that there was a mistake? Then cost.
Your Lordship will not.
This court have duly taken note of. Paragraph number 10 of the writ petition, wherein also there was a mistake committed by the petitioner in drafting of the writ petition, and therein it was mentioned as the third RA bill on 21/8/2006. It is under such circumstances the said error had crept in the judgment in paragraph number 3 of the judgment and order dated 23/11/2023. However, this court have duly taken note of the Annexure 4 series
Page 71.
which shows the date ought to have been 21/8/2020. So, taking into account for the interest of justice, this court therefore corrects the words the third RA bill on 21/8/2006 appearing in paragraph number 3 of the judgment and order dated 24/11/2023 to by should be read as the third RA bill on 21/8/2020 in paragraph number 20, paragraph number 3 of the judgment and order dated 24/11/2023. With the instant order shall be a part of the judgment and order dated 24/11/2023. So, taking into account that it was on account of the mistake committed by the lawyer which has led to this correction, which has caused delay, which had spoiled the judicial time of this court. This court imposes a cost of rupees 50,
Oh, Lordship.
70, cost of 10,000 to be deposited by the petitioner before the registry of this court, which shall be thereupon transferred to the legal services authority by the registry.
Oh, Lordship.
The compliance period was before parting with the record. This court, however, taking into account that these mistakes have been now corrected period. The direction to comply by the respondent authorities shall be counted from the date of from today.
Lordship, my instruction, he already submitted before the chief engineer, Lordship, and it is already processed. Lordship.
From the date of submission of a fresh corrected certified copy of the order before the respondent number 3, along with the fresh corrected judgment and order dated 23/11/2023, along with a copy of certified copy of the present order to the respondent.
Item 12,
Yes, what is this?
May I please, your Lordship, the grievances of the petitioners are fulfilled, Lordship.
Huh?
Grievances of the petitioners are all
Fulfill.
fulfilled.
The learned counsel appearing on behalf of the petitioner submits that the grievances of the petitioner have been duly taken care of, have already been resolved. The grievance of the petitioner, which have been assailed in the instant proceedings, have been already resolved, for which he wants to withdraw the instant proceedings. Accordingly, the instant proceedings stands closed on withdrawal.
item 14,
Yes, MFA. No MFA people. You are ISIS here. Huh? No. Appeal admitted. Call for the records. Issue notice to the. Who is appearing for Union of India? None. Are you there? The appeal. Now, this is an appeal against the judgment and order dated 20/12/2023 passed by the Learned Railway Claims Tribunal, Guwahati Bench in OA Roman 2 U small dash 44/2023. The appeal is admitted. Call for the records. Ms. So-and-so accepts notice on behalf of the respondent number 1. The appellant is directed to serve extra copy of the instant memo of appeal to her within 3 days. List for hearing upon receipt of the records.
in
Yes.
Appeal against an injunction order. Order is a case number 113.
Who had granted an injunction?
I thought the court of the civil senior division
Granted an injunction.
restraining the present minor appellant from constructing a 3-story building.
Therefore, this court deems it fit and proper to continue with the order of injunction passed by this court, directing the opposite party as well as to maintain status quo in the. Then ISA. ISA. No A. Then what do you want? What am I going to do?
I have to submit. The matter might take it up with market.
I give you 6 weeks time. Don't you know the basic idea? Then when you are filing an application, either you have to ask for stay.
Yes.
This court can only say that this order is right or wrong. Yeah. We should notice. Appeal. What is the ground? Let us see. What is wrong?
The thing is that basically it's a partition for partition.
Who are you?
I am the and then
Understood. Who are you? You are the
I am
Nihar Kanti Chaudhary.
the teacher there of Vidal country.
You have You are constructing a whole house
Yes, on over 1 acres of that.
out of,
Out of
what
that,
is the partition?
Your Lordship will kindly see the schedule of the plane
Hmm.
at page number 35. Schedule A, schedule B, and schedule C. So by when such a partition, unless and until partition is done, it cannot be said that some legal layer cannot have a title or right for a particular plot of land. When the basically by not after death by not constructed a house. The
Understood, but tomorrow if you construct a house.
Yes.
After you construct the house and in partition, there
Yes.
will be a problem of, find out the question of OLT. If it is found that this is the amount to be paid by you, or this is the land which he has to be given to
at
them,
our own risk,
then-
we are constructing.
Huh?
Tomorrow by not if they found out that we are constructing the land for the share of somebody else, then definitely we have to demolish it at our own cost. But now, my lord, because of this order, the construction work has been stayed.
very well,
We are my
rightly
lord,
done.
suffering.
Why should we interfere?
We are
It's
suffering.
it's a exercise of jurisdiction under the equitable jurisdiction. What
Yes.
is wrong?
Yes.
There's nothing wrong. I think this is a fit case for dismissal on the face of it.
But here's the question. What the purpose? Here, my lord, but if
Wonder versus Entox, paragraph 14
Yes.
categorically says out there that this court should not, first appellate court should not exercise its jurisdiction unnecessarily over the equitable jurisdiction exercise unless you say it to be arbitrary, unreasonable, perverse, and against the well-settled principles of law.
Yes.
If that be so, you are asking this court that I should dismiss the appeal right away.
no, my humble submission is that if Garnet Court below fail to exercise this discipline,
Faith? What faith?
because my lord, it's a
Granting an injunction is failing?
no, my lord, it's a for my lord party.
You want something more?
No, my lord,
Then
but my lord, but if the alienation or
I will be sitting this entire month in this bench. So better take it up after 3 weeks. At the request of the learned counsel for the petitioner who submits that he would like to file an interlocutory application, matters stands adjourned to be listed in the first week of April.
Hello.
Supplementary item 56.
Yes, what is this?
My order against the decision of the injunction order. By injunction. And the order is at page 59. Here, my lord, as far as the electricity board is concerned, that is the Assam Power Distribution Company by for disconnection of the road and for the for declaration of right, I have had two facts. Now, my lord, the respondents number 3 and 4, who are the unauthorized occupants, they got the electric connection in their name regarding the premises it was I am the owner thereof. Annexing there with the sale deed man. The note sale deed, agreement for sale man. That they have entered in sale deed, sale agreement.
What is the injunction you asked for?
Mandatory injunction, my lord, directing the respondents of 1 and 2 to disconnect the electricity.
Of?
supply. This was
Disconnect the
granted in-
electricity of whom?
It was granted in the name of dependent, number 3 and 4. That's what it said.
3 and 4.
3 and 4. Who are the unauthorized occupants and they took a possession.
So what is your right?
I am the owner, man. I am the owner. They are claiming their right. on the
Hello, we
basis
can
of
give,
the-
we can do one thing. You disconnect in his name, give a separate connection as per the judgment of the Supreme Court. Dinesh Dilip dead.
Yeah.
First we'll issue notice. Then after issuing notice, we will do it. Dilip dead. No, this is not a case for granted, but nothing is wrong with them. Eh? No. We can do anything if he's aggrieved, his name is being used, you give a separate connection to him. So as of now, let us hear the other side. Taking into account that the instant appeal is an appeal filed under Order 43, Rule 1R of the Code of Civil Procedure 1908. This court, for the ends of justice, is of the opinion that the respondent number 3 and 4 to the appeal memo is required to be heard before even admitting the appeal. So considering the above, this court issues notice returnable by 3rd of April 2024. Mr. So-and-so appearing on behalf of the respondent number 1 and 2 duly accepts the notice. Extra copies of the memo of appeal along with the, you have filed any application?
Yes.
Along with the interlocutory application be served upon him within 3 days. As regards the respondent number 3 and 4, the appellant is directed to take steps by way of registered as well as usual. Dusty?
Not bad.
No, Dusty. Very nearby. You should have done it.
But by registered date.
Huh?
Registered date, my
Right. Then you fix it on 8th of April, huh? On we registered with the 80 as well as usual process upon the respondent number 3 and 4, along with the instant memo of appeal and the injunction, as well as the interlocutory application.
Item
I
61.
cannot to issue notice taking. Yes, RERA appeal. What is this? Who are you? Who are you? Operation department. Wait. Huh? What does the cooperation department has to do with RERA? Oh, good. Yes, tell me. He is the builder.
I'm the
Hmm. Like give the flat to
the picture position is not. The picture position is that I was the builder. I was appointed as a builder to construct the plate, and I have constructed up to 1st floor. And he was the purchaser, and he has entered into an agreement with me. And
he has not entered. Both of you entered.
both of
Yes.
she has entered with me, and after receipt of the consideration amount, I have handed over the position of the plate
To her.
to her,
Ah.
and she has taken the position as per the possession letter he has also accepted. And thereafter, the landowner and I have cancelled the earlier agreement, development agreement and the power, wherein the landowner acknowledged that he will sell out the property which I have already entered into a two agreement with the different purchases, including the complaint respondent on number 1. Then after the possession was handed over to
Is it
her
stay?
on
Is it stay operating?
2011-2015.
Now, if there's no stay out there, why are you not getting it executed? There's no stay. Then why? Hello. Is there any urgency? All matters are urgent. Everybody has an urgency. What? Why do I need a LCR? So many documents here enclosed. Nothing. So, whether the learned first appellate court below erred in law by not framing the point for determination. CPC does not apply. Then, for that, the substantial question of law is whether the case by AI is a specific performance of contract, and he is not asking for specific performance before the RERA. He is asking a statutory relief. So 54 does not come. For that, the substance is whether the respondent number 1 who never took actual possession can claim recovery of possession, and section 64. How do you bring in 64 of the limited?
On there,
Chalo, we do one thing. We good date for dismissing? Any good date for dismissing your appeal? When? When?
whenever
I am always free. No, now. Today I think, you see, I've got only 3 stenographers, so many disposal. These people have to type out. Where will these people type? They leave it on when? Until. Let us hear after Tuesday. So let us hear the person who will be affected. He should be given more. No. As a lawyer, he will be more affected. The pressure is on you, but he will be more affected. If I am to allow the appeal, then I would have asked. Now, when do you want it? Tomorrow, day after.
No, next.
Not Friday, we'll have it on 14th. 14th. List the matter on 14th. An attempt shall be made to dispose of the appeal at the admission. Liberty is given to the parties to mention the matter for appeal. Yes, Mr. You are this side. Huh? No, you are not this. You are state of Assam.
So one is give it to the other.
Hello. Some application has come. Some application has come.
Lord, maybe please to take one of the copies. It has been filed already.
Right. I also Koran
Already filed, Lord. 10th and every.
Hmm.
Okay. So we will put the contents of this. Put the contents in the order.
Yes.
And you have also during given the two checks of
One check
37
will
lakhs.
give, and while one check will give to him, the other, that 10% TDS component,
Ah.
that is written as yourself, so our department will.
That you will do it.
Yes.
That is already
Yes.
reflected.
Yes.
So there will be two checks of 41 lakhs or 37 lakhs.
37 lakhs.
And the fourth amount is the 4 lakhs 12,000 will
That
be
I'll
the
keep.
10%
Yes,
deduction.
I'll keep that.
Oh.
The department will deposit.
So that you will be deposited.
So this check I'll give it to the other
No,
side.
this order reflecting that this 4 lakhs you will be depositing.
Yes.
I think that will take care of his life.
4
4 crores. 4 crores will be deposited. Both the repeat.
These are the two things.
The repeated being CRP number 75 of 2015 and WPC number 453 of 2022 are taken up together, taking into account the similarity of the issues involved. I've heard Mr. D. Soike, the learned Advocate General, Government of Assam, assisted by Mr. B. Gogoi, the Standing Counsel of the Health and Family Welfare Department. And I've also heard Mr. S.P. Roy, the learned counsel, appearing on behalf of MSJD Pharmaceuticals. It has been brought to the attention of this court by way of a joint affidavit filed today that the total dues of the said JD Pharmaceuticals Limited. What is this JD Pharmaceuticals?
Pharmaceutical.
Who is the petitioner in deputy number 4563 of 2022, have been amicably resolved between the Health and Family Welfare Department of the Government of Assam and the said JD Pharmaceuticals, MS JD Pharmaceuticals. The total dues which have been worked out, which would amicably resolve the decretal amount in respect to the judgment and decrees passed in Manisuit number 242/93, 245/93, 244/93, 248/93, 241/93, 64/94, 190/94, 246/93, 20/94, 190/93, 247/93, 188/93, 228/93, 189/94, 188/94, and 66/94 is an amount of rupees 41 crores 24 lakhs 19,280 words only. Of the said amount of 41, 24, 19, 280, an amount of rupees 37 lakhs, 37 crores, 11 lakhs, 77,352 had been paid to the petition, to the said JD MSJD pharmaceutical by handing over a check bearing number 285643 dated 4/3/2024. The remaining amount, which is the applicable deduction of tax, that is an amount of rupees 4 crores 12 lakh 41,928, shall be deposited by the state before the competent authority as the amount payable as deduction towards TDS. This aspect of the matter could be seen from paragraph number 3 and 4 of the joint affidavit filed by the state of Assam, by the Health and Family Welfare Department, by the Joint Secretary of the Health and Family Welfare Department, along with the proprietor of MS, proprietor or partner, so the partner, along with the partner of late MS JD Pharmaceuticals. Paragraph 3 and 4 of the said affidavit is reproduced herein below. 3, 4, and 5 of the said affidavit is reproduced herein below. Taking into account the above and above, both the views, taking into account the above, taking into account the above and the fact that the payment of rupees 37 crores 11 lakhs 77,352 have been duly paid by the way of a check number 285643 dated 4/3/2024, and the state of Assam is going to deposit the remaining amount of rupees 4 crores 12 lakhs 41,928 as the applicable TDS before the competent authority. The decrees passed in the aforementioned suit stands satisfied, and accordingly, the money execution cases number 1/96, 14/97, 15/97, 16/97, 8/98, 10/98, 19/98, 23/98, 30/98, 1/99, 3/99, 38/99, 7/2000, 12/2003, 17/2003, and what? Yeah, stands closed. Stands closed. And disposed of on the basis of the instant order. You get the call for that, huh? The original one.
So I'm giving it to the other side now.
You give it to me.
Not the- Just for Lordship's concern. What exactly happened?
No, that is why I asked you, because these are civil matters. So civil matters require these type of application to close it.
Yes.
If I just say that it
Understood.
has been closed, you will have a lot of problems. The execution cases cannot be closed in this manner. It has to be closed in there. So it may be a tiring thing for me to keep on repeating the numbers, but what? CPC has to do, because this will be done in terms with Order 21 Rule 2. Yes.
That Lordship.
Right. All the,
deeply obliged.
the fact file is. Mr. Gogo, you kindly ensure the affidavit is brought during the court. Can you just take
I
your
will
time
have
going?
it liquid.
Huh?
I will have it.
Please do. Take on it. Itu mau order to suhi court takutnya affidavit like. Huh? Ano, original court. Yes, ask your junior. Get it.
17.
My lord, the second appeal. In this particular case, my lord, I filed this suit for declaration of title right and title. And the suit by both the courts below my was dismissed.
What is this case about?
Suit for declaration of title right and interest my lord, in relation to certain land my lord, which has been given as right my lord. And the issues, my lord, your lordship will find. The issues in this part is that is 19 of the appellate court.
Yeah, appeal has been dismissed.
Yes, appeal was dismissed, suit was dismissed, appeal was.
So it is double reversal.
Yes.
Now what to do?
My lord, there are.
What is a
certain-
substantial question of law?
Yes, my lord. The first substantial question of law, my lord, your lordship will see at page
There is no jurisdiction to entertain the suit in view of section 11, 18, and 13, inasmuch as the prayer plaintiff has prayed for declaration of title and further for declaration that none of the defendants have any title. This land was acquired.
it was acquired by the government, and I am not the interested person, even though the land belongs to me, my, but I am not the interested person claim. Compulsion under section 8,
You are not interested person.
because I have not been allowed to take the money. Because
Did you
according
file
to
an application under section 18?
18, I cannot file, my lord, because until and unless I am one of the interested person.
So you don't
take
fall within the ambit of the person interested.
interest.
You are not.
Yes, according to them.
No, not according to them. You do you
Yes.
as per you.
Yes, according to me, I am entitled. to
Then why didn't you file in section 18?
Because there is a bar. Your lordship will come to section 8,
Section
18.
18.
of
What?
acquisition.
What does section 18 say?
18 says, my lord, any person
So what is person interested?
interested, my lord, they have been decided, my lord.
No,
that
it has been defined.
Yes, I filed
Anybody who
Ma-
claims that he has an interest over the land.
over the day.
You have a
I-
claim?
Yes, I have the claim.
Then
I
you should have
filed,
gone.
I filed the objection, but even though my objection was rejected, and consequently, my
No,
lord,
your objection, did you file a section 18?
18, not 18,
What did you file?
before the DC, before the DC.
So that should be an application that the moment you file it before the DC,
And-
that will be taken as
and-
18.
First root, my lord, your lordship may come.
So this
Yes,
one is no ground.
any person interested who has not accepted the award.
So?
Who can file it? The person interested who has not accepted the award. No award has been made in my.
Huh?
No award has been made in my favor. But your lordship,
Did you accept? No, this is done because of section 30. See section 30, wherein it says that some people, if you have to take it under protest, the money, then that is the reason why who have not accepted. I has to take it under protest.
that is the, apart from it, my lord, so far this issue is concerned. That was not saved by the tribe.
And that is false.
But
Nothing.
It,
If you don't succeed in the first
no,
18,
no,
whether
so
you
far-
are a person interested, you
so
should
far
have gone.
this issue is concerned, my lord, that has not been saved by the landed tribe.
This issue was not framed by the learned trial court. This issue was not framed at all by the learned trial court.
But did the appellate court decide that?
It decided without giving me the opportunity.
You were the
What?
appellant?
Yes.
You were the appellant?
Yes, I was.
You didn't argue?
Because this issue was not made known to me, man.
Why?
Because your lordship will come at page 41, the issues framed by the learned lower appellate court.
What is your basis on saying that this issue was never brought to your attention?
Yes, my lord.
There is not even a ground of appeal.
Because I did not take the ground. Then it was not the issue before the learned trial.
Here also you have not taken the grounds of appeal. You should have taken the grounds in appeal.
Yes.
Isn't it required in terms with order? This appeal is done under order 42.
What?
Order 42 rule 2 categorically mentions that the provisions of order 41 rule 1 shall apply. And as such, when order 41 rule 1 says that there is a requirement of stating the grounds of objection, why there is no?
But even though your lordship may come to page 41. Page 41. That is issue number 1, whether the duty in the court to try to put it past. And whether the jurisdiction of this court has put it past. This issue was, sorry my lord, this issue was same. But that has not been answered.
Yeah, rightly done. Paragraph 12 of the impugned judgment. Hello. Let us not dismiss it in the late hours of the day today.
Why not question to provide?
Huh?
Substantial questions to provide kindly be framed. So that
First of all, your appeal, the suit was not maintainable. Matter ends there. All other things have no consequence. Why should we go into other things? Section 18 categorically says that you are to go before the district judge. You should have done.
could have that much. Because it is only the intention that
Now also go. Why don't you go now?
yes, your lordship is
I need not. You categorically say. You say that I'm going to withdraw. I'll give you. Okay. However, the appellant would like to, you say that the appellant would like to appear, file appropriate application, and the period during which the entire proceeding shall be there, shall be condoned in taking, in filing.
My lord, your lordship may also condone.
Huh?
Your lordship may also condone this demand. I would file the application, but even though your lordship may also condone in filing the.
But this acquisition was done under the
application
1894 Act. This was done under the 1894 Act.
Yes.
Or under the 65 Act, 64.
1980.
1894.
Yes.
So 1894, then obviously it has to be 6 weeks or 6 months.
6 months.
6 weeks or 6 months. But the thing that during this proceeding, you were fighting out there should be excluded. That
Your
can be a
lordship-
fair. Think about it.
If your lordship direct for condonation of the delay, in that case, I
We will think over it. Ask your client. Not today. Anyway, summary. That is the only way out. Mr. Bhatti, at the end of the day, this is going to dismiss and your client is going to lose. In fact, that was my basic thing which I told both the counsels in the earlier matter when I was taking that. Unless the delaying is not going to help you out, the money would be finished. You should have immediately stopped
That's
and
why
moved
my
to
lord,
section 18.
that is why that decision mechanism is not giving me the liberty to fight the condonation.
Some other day, Wednesday. Today is Wednesday, na?
My lord,
We'll have it on Monday.
on 11th, I'm going to Rajasthan.
We are
That is
going to
my
Rajasthan.
tomorrow, latest tomorrow.
Okay, tomorrow. Think over it.
Yes, my lord, if the delay is contract in that case, I have it.
But what will happen if the money has already gone?
No, still it has
Not even.
according to my.
We take that.
Same matter, item 49.
Ah.
have taken except upon the respondent, it is taken upon the respondent,
Ah.
but all the respondents refused it.
They appeared?
No, Lord, they have refused.
They refused?
Yes.
Then the service is complete?
Complete, they come up for admission.
Okay, the learned Mr. H. Puragwai, the learned counsel appearing on behalf of the petitioner submits that the service upon the respondent is complete, taking into account that all the respondents have refused. Taking into account the above, this the matter again on when? Huh?
Any day.
What is the order? There is no stay.
There's no day.
Huh?
No.
Then what remains out?
They was only here, Your Honor.
Stay has been vacated.
Under-
What did you file out here? What remains?
I'm not in this case, Your Lord.
Huh?
I'm not in this case, Your Lord. I have got instructions.
Okay.
here.
Service is complete. List for admission on Wednesday.
So like,
List it Wednesday next, taking into account that there is no stay. Okay. You want to file time? None appears on behalf of the petitioner on call. Mr. So-and-so has appeared on behalf of the respondent. It further appears that on the earlier occasion, also on 29/11/2023, none has appeared on behalf of the petitioner on call. Taking into account the above, it seems the petitioner is not interested in the further proceedings of the instant further proceeding. Be that as it may, as a matter of for interest of justice, the matter stands adjourned to be listed again. March 2024. It is observed that if none appears on behalf of the petitioner, the instant proceeding shall be dismissed for non-prosecution.
51.
Yes, what is this?
We have challenged the impugned order, that is case 46, where my wife has filed so many cases against me at Bongaigaon, at Awagri, and also at Subi. including my old age mother. She cannot work properly. For all these reasons, I tried to bring her back to my company by way of filing title suit for restitution of conjugal rights. Even then, she did not come. So I have withdrawn and thereafter I have filed divorce. Now the landed court has granted rupees 15,000 per month as alimony and 30,000.
Wait. Where is that order?
Yes, 46.
46. Rupees
operative portion
15,000
is-
directed to
it
pay
is from
monthly
44.
maintenance of rupees 15,000 to the petitioner and a minor child during the pendency. The state maintenance shall be payable for 1st of February. It also directed to pay an AR litigation. So what is your, what do you do?
I am a government servant, my lord. I received
Government servant. How many children you have?
I have told as a father,
No, forget about brothers. How many children you have?
21.
Children is with whom?
But-
Then
Uh,
what are you going to do? Only 15,000 has
No,
been given.
No money. To my,
Yes.
to my child,
Are
I
you
am
not
ready to
filing a
pay.
cross objection for increasing it to around 45,000? What does he do? He's a what teacher is he? Huh? I can't hear your voice. What is wrong with you? Assistant teacher, what is his income?
His income above 50, my
About 50?
above 50, my lord.
Assistant
That is-
teacher gets
No,
50,000?
my lord.
Then what are you going to do?
49,430.
Yeah. You have got a lot of money.
No, but the thing is,
15,000, what is wrong?
And there is no
I have
other
taken
dependent, my
loan
lord.
of rupees 30,000, madam.
Don't. Why have you taken the loan?
For-
One should cut it close according to its length.
And every month I shall have to pay the EMI. And in that manner, my lord, by 20 rupees, 22,860 goes. Then my old age mother, she needs at least 10 to 15,000 per month for her treatment.
Mr. Mahmood, this court finds no ground to interfere with you.
Now I have already paid rupees 30,000.
Huh?
Already I have paid rupees 30,000.
Fantastic. And this paid is 15,000. Your daughter, where will it? Daughter or son?
Daughter I will pay, but my lord, her conduct is not at all good. I am satisfied. So far daughter is concerned, I will pay.
So to pay in the name of the daughter 15,000. Hmm. Yes, after all, if we have a father-like figure,
No, I am ready to pay, but a reasonable amount.
15,000 is reasonable. It is 30% of what you are getting.
I am getting only rupees now, unless 7,860 after all deductions. But everything is on record, man.
Show me their salary slip.
Yes, salary slip.
Where is your
My lord,
salary?
page number 36.
Huh?
Page number 36A, my lord.
36.
36A, my lord. There is an
No. These type of
Yes.
loan does not happen.
Right.
Where is your salary slip? Where is
Yes,
your
sir,
number
36A.
36A.
where is your passbook?
Passbook.
Why have you not enclosed the passbook? The passbook will show the amount is reflected.
Yes, that page shown, madam.
Then how much does it come? Show me why the passbook has not been enclosed.
Well, my lord, I get rupees 49,430.
No, 50%, 30% you have paid. Very lucky.
That's
No, no, my lord, I have always mother. She is totally dependent upon me. I have to treat her.
Who?
My old mother with me.
Treat her also. Remaining processes,
She
remaining
is not
60% is with you.
I was in hospital for 81 days at JMCA. 81 days she did not come to see me.
We didn't pay her litigation expenses, so she didn't come.
No, my lord, I will also show this other conduct is also not at
No,
all.
Mr. Counsel, doesn't look nice.
as part.
Yes, 49,332. And deduction is how much?
Deduction
The deduction is only 5,000.
no.
Yes,
Deduction, no. My lord.
36A. Page 36A. And this must have increased with
No,
DA
but I have
now.
one thing, my lord.
May 2022.
After
Yes,
my
sir, that's
salary
He
is
must have got 4 DAs in the meantime.
That is the one May.
I I have given the whole clear picture, 49,432 I get. Then after reduction, I get rupees 22,000.
Where? The deduction at page 36A.
Page 84 and 85.
Page
84 and 85.
84. What is that? Page 84 is different. Some declaration.
Declaration. For speed on property.
84 is also the compromise that receive left by company voluntarily. Here everything I have distributed. Kindly see page 81 method. There are 13.
These are nothing. This page 36A is the main document. I don't see any good ground.
No,
Is there any stay?
My lord, say.
How we vacate the stay? I'll do whatever you like. You vacate
No,
the
before that, my lord,
There is nothing out
the
there.
hearing is necessary, my lord.
No
And the
hearing.
court order is there. When the
Mr. Mahmood, how much hearing is
No,
required? We have
let me-
already heard you.
let me say this, your lordship. When mother-in-law is irritated by the daughter-in-law, then that is a good ground for divorce as well as depriving her from her maintenance. So I am saying only that at present, lordship, I have.
Show me that any judgment that it deprives her from maintenance. Show me that. Obviously not there. That cannot be the law.
No, that is
That might
ground
be a
for
good.
divorce.
That might be a good ground for cruelty. That
Cruelty?
might be a good ground for divorce, but not to deprive her from maintenance at the stage of when that aspect
She
is yet to
MSc
be
pass.
decided.
I think she's MSc pass and she's also earning something.
I'm not going to extend the interim order. Okay, when do you want? After 6 months to get a proper hearing? I'm not going to
Before
extend the interim.
vacating, whether that a thorough hearing be taken.
I've heard it.
The
For me,
whole
I have heard it. I'm
whole
not going to
story
extend it.
disposed of it. I'll say to your lordship on this point.
No, I'm not
20 let
satisfied.
loose on me by her, not by me.
Okay, leave the matter again on. When do you want it?
Let's get-
Okay, leave the matter again on 13th of March 2024. This court is not inclined to extend the matter hearing, taking into account the prima facie. This court does not find good grounds for extending the stay order. This court, however, on the next date shall again take a call as to whether the stay order could be extended.
Ma'am.
But I think you file a counterclaim or do something. You should increase it to 50%, not 30%. Instead of 2% against 1%. Why does the father need so much money? He's earning for the daughter only. Yes. Yes. What have you done? It's such a big matter.
What
Huh?
done for me, my lord, it's a
Huh?
problem. I filed an application under section 34 before the learned district judge, my lord. What happened? Order was passed in open court, where my learned junior judge and thanks God my officer also was present. That order been, I'm not on the first part, but that part, means case where 36 was moved, that I have shown that petitioner advocate is absent. Whereas I was present. Thereafter, being helpless, I filed a complaint petition here. Thereafter, he has done a district judge corrected. He admitted that it was fault of computer stuff. And
Then what is wrong?
no, my lord. Here who I am happy. The lordship.
Mr. Borua, I know this matter. The reason why I know, I am the portfolio judge.
I know
I
that
had
is
the
why I know.
consultation with the judge. He thereafter also corrected it, said
Yes,
that there was a mistake on the
Yes,
part of her not being informed. Don't think there is any case of bias out there.
No,
I think
that's
there-
it. That is why only my suspension because initial date I was being.
No, the reason why it has happened out there, as I could learn, you reached around 12 o'clock.
Yes.
Yes. Prior to that, when the matter was taken up, listen, prior to that, when the matter was taken up, order was passed that there was none who have appeared. Thereupon, when you appeared before the court, he said, okay, and accordingly he passed that order to his stenographer and said that this order will be passed. In the meantime, what has happened, the earlier order given, and due to the thing, yes, wrongly, he has signed that earlier order wherein it was shown that none has appeared. And when you took the steps for notice out there, there was no order
That
passed
is
through.
all the fact.
So later on, when this aspect was pointed out to him and it was brought to the notice of the court, this aspect, when it was pointed out, then what do you call, I, being the portfolio judge out there, had a consult with him. Then he corrected that also, that he admitted that there was a fault. I don't think this is the, because I don't think Mr. Burrow kindly appreciate, this is not a case for which
I am not.
taking up this matter out here or issuing some notice or transfer out there to show more light on the judicial officer. He's otherwise.
Now, I'm not against condition lordship purchase because my I have to file my lord because I'm
I don't know.
that is why now lordship. Yeah, lordship.
I'll do one thing.
Whatever, Millard, whoever
I'll-
comes, Millard.
I will say that your ground is on reasonable apprehension bias.
Yes, Mr.
I'll dismiss
And
it.
Millard, I'll appear what I'm not having
No,
any
no,
partial ability.
Mr.
Anyone,
Burrow,
Millard.
rest assured, otherwise,
Yes, yes.
only that was a fault which he
No.
duly accepted in an order.
Yes.
In a judicial order, nobody normally would have accepted it. He has accepted in a judicial order.
No.
It was his
That
mistake.
is why, my lord, truly speaking, when matter has come before us, happy that I know this will come because the lordship, because your lordship is the in charge honorable judge. I also know because I have seen the board also. Where that your lordship has inaugurated that building. That is why from that I have come to. Anyway, I'll be appearing, my lord. No, this one I don't have any personal opinion with any honorable judges. Why?
No,
It's not
it's
my personal
okay.
matter.
No.
Only this observation should be there a little bit. That no, because what my feelings was there. Why I have
Yeah,
to-
feeling, no feeling, I'll do one thing. This is an application filed under section 24. Read with section 151 of the Code of Civil Procedure 1908 for transferring the case being arbitration main case number 01/2023 along with Miss Arbitration case number 01/2023 from the court of the learned district judge, from the court of Mr. Roshan La, learned district and session judge, Karbi Anglo, to any other competent court to try and dispose of the same. The instant application has been filed apprehending bias on account of the allegations made in the application on the basis of various allegations apprehending bias. The basis of this court have duly taken note of the materials on record and further taking into account that the learned district and session judge Karbi Anglo had duly accepted the mistake which he had committed by rectifying or modifying and also stating the mistake in his order, which in this opinion of this court shows his magnanimity, for which I don't feel this court is of the opinion that the likelihood of bias which have been alleged does not arise. Consequently, this court finds no ground for entertaining the instant petition, for which the petition stands dismissed. Don't worry.
Yes, and
Interim order pursuant
I
to stand
don't
vacating.
worry, Millard. Now.
The parties are directed to appear before the trial court on 8th of April.
Right.
I order. Yes, any urgency? No urgency. Well, yes, Mr. Doctor.
Lordship, I have an item number 58 in the supplementary.
What is that?
It is for order, but it appears that the respondent numbers 6 and 9 service is everything, but they were not contesting the matter. They were not contesting the matter. So therefore, if your lordship pleases to pass an order to put up it for a admission hearing. It's a 17 matter, your lordship.
That won't be proper.
And another partitions, another RFA is there, both to be tagged together. Same part. That is a limited.
No urgency. Any
No
urgency?
necessary for a step.
Item number 23, my lord. Service is complete, my lord. It's for hearing, my lord.
Huh?
15 matter only.
What has happened?
My lord, service is complete, my lord. They came for order.
Item number 23. LCR received.
Yes.
Item number 23.
MJ Kaki.
Appearing on behalf of the appellant submits that the service is complete and LCR have been duly received. Taking into account above the second appeal.
Yes.
The regular second appeal be listed for hearing in individual court.
Because that is the 15 matter.
What? Who is going to finish the 2010 matter, 2007 matter? Somebody has to do it.
Well, item 24 may be listed after being written.
So is there any order what I mentioned? RFA number 72 of 2017.
Yes.
The respondent is waiting for the service of respondent was 6 and 9. Now they were not contesting in the trial court. Expertise against them, the expertise proceeding as well. So those not necessary for waiting further. So this is my first submission, and second is that is on another matter. This is RFA number 51 of 2019. All parties are same. There is a partition suit. We are a plaintiff there. So both may taken together by this number 4. That's my only step.
That matter is not before this court.
No, not today.
List, item number?
Item number 58.
Item number 58.
Subject.
List the matter along with RFA number
51 of 2019.
51 of 2019
on any day, Your Lordship, please. During this month,
10th of April.
During this month, say over 2nd of April. Your Lordship.
2nd of April.
Second.
No, 3rd of April.
The 3rd of April, Your Lordship. Either 1st of April or 2nd.
1st of April.
May I also request another item, item number 48. This is the hearing matter. Lordship, may kindly fix the date. It's the 75 years old.
Who mentioned the matter by order?
No, this is a hearing matter.
Understood. By order, how a hearing matter has been fixed. Who is that ingenious person who has done that? No, mention
48.
48 to mention. Why the matter come by order? Who has the ingenuity of mentioning the matter? Why have you done that?
I don't know.
Is this the manner? Can a hearing matter be mentioned by order? And who is the judge who has given it? Let the matter be listed before the judge, whoever has given it.
Court number perhaps 15, 40.
15, huh? 40.
48 euros.
48. 48 or Lekhi. That taking into account that this the matter before any other court without me.
Why, Lordship?
No, because first and foremost, if the judge has given that order to be listed for hearing on the basis of a mention memo, I think that court should take it up, not this court.
Lordship,
Lordship, so list the matter before any other court without. Yes.
Item number 51.
What do you want?
May I have any date Lordship listing of this case hearing?
Hearing?
LK has been received, Lordship. LK has been
Lordship.
received,
Good.
Hearing?
Needed
RFA admitted.
Admit.
Why is the matter come up for order?
Order, Lordship. Actually, cause of the objection has been filed by the second party.
Cross objection. That cross
Because
objection has to be admitted.
admitted. Lordship, earlier delay was there, but delay gone down and it has been admitted.
But has the cross objection been admitted or not?
Also, this will part not suit. I have filed RFA. Also, it's nice.
Okay, list the matter on next paper. Let the matter be listed on 20, 23, 2024. Huh? For orders. It has come up for orders, no?
Order.
Please.